Okay. This is the regular meeting of the Sunshine Ordinance Task Force called to order on Wednesday, January 6th at 4 o'clock. Mr. Young, would you call the roll, please?
On call of the roll, Member Rummold.
Present.
Rummold present. Member Eldon.
Present.
Eldon present. Member Wolf. Wolf absent. Member Copra. Copra absent. Member Pilpil.
Present.
Pilpil present. Member Haynes.
Present.
Haynes present. Member Fisher.
Present.
Fisher present. Member Hinsey.
Present.
Hinsey present. Vice Chair Hyland. Hyland absent. Chair Washburn.
Present.
Washburn present. We have a quorum. On agenda changes, I have like to note that item 5 and 6 regarding Mr. Warren, he has requested a continuance of the matter. He did submit his continuance request 5 business days prior to the meeting, so I did inform him that the continuance was granted.
All right, thank you.
And that's to the next meeting? Or to the call of the chair?
I'm working with both parties at this time.
Okay, all right, thank you.
Do you want to introduce Andrea as well?
I will allow her to introduce.
Okay, right. Good afternoon. This is Andrea Osbury, previous Sunshine Administrator, sitting in for the full meeting today.
Oh, thank you. Welcome. You were here briefly last time, I believe. Yeah, okay.
We might see more of her, maybe.
All right. So, Mr. Young, would you call the next item on the agenda, please?
Item number 2, file number 14030, amendments to the Sunshine Ordinance Task Force complaint procedures.
All right. We've seen this matter a number of times before. I trust that everyone had a chance to look over the packet. In addition, we received some memoranda, or two memoranda, one from Mr. Grossman and one from former Chair Nee regarding some edits, and I don't know if everybody got these. I know
We just
Vice Chair.
at our table.
Some of this, some of this that we had emailed to us, or I know that I received it. I'd like to give the members a chance to weigh in. Then we have members who are present here who submitted materials. We have this, Mr. Warfield. For those of you who are fairly new to this body, Mr. Young has been working to revise these procedures for some time, and we've seen them in the past. So there's some new additions because of a change we implemented about a year ago on a trial basis. It's now about a year and a half ago to reconstitute the complaint committee to help us with the enormous backlog we had at the time. So there's information about this. You have copies of a clean copy as of the end of September, and then you have a marked up copy. And you should have gotten some of the materials from members of the public as part of the packet. At this time, members, anyone have any
Can I?
questions, comments? Member Pilpel?
I'm just going through the new material. I would like to hear from Mr. Nee and Mr. Warfield, but I had a specific question for Mr. Nee, if I might, at this time.
Sure. Let's first, Mr. Nee, would you maybe recap some of the I went through your what you submitted, and some were typos that I saw as well, but you caught some new ones. Excuse me. DCA 3? Am I doing something wrong here?
No, Chair Washburn, through the chair, just to remind the task force that when members of the public speak, the same amount of time will have to be provided to each member of the public.
Okay. So
Well,
at this, well,
can I just clarify? When we ask for public comment, that applies if we direct a question to a member or to a member of the public. Don't they have an opportunity to answer that without limitation on time?
That is true, Member Bilbao.
Okay.
so why don't we, maybe it'll make sense for Mr. Nee and then Mr. Warfield,
That's fine.
anybody else who's here, to speak for up to 5 minutes, and then we'll ask questions, and it'll be a more open forum. So,
That works too.
former Chair Nee, if you would.
Yeah, good afternoon, task force members. Richard Nee, former member of the task force. I'm having a little bit of a problem in that I wanted to print out the memo that I sent you, and unfortunately my computer had a malfunction that required me to take it into the shop, so I wasn't able to do that. I'm speaking right off the top of my memory, which is a bit cloudy. So what I'm going to do is just give you...
Just a minute. Here, Mr. Young has a copy right now.
Oh.
There you go.
Thank you very much, Mr. Young. That's much appreciated. Bear with me. Right off the top, I don't know if this is by a deliberate omission or if it's some kind of a or inadvertent omission or anyway, there are apparently some parts of it that are missing from your packet. In section C, it jumps from paragraph 8 to paragraph 11. And I'm wondering where 9 and 10 are. Also, it jumps from section section C to section E. There's no section D in there. So again, something's missing. And that being the case, you might not be able to act on this today. Other than that, I think what I've...
Mr. Nee, I was similarly confused when I looked at this last night, and I'd seen your comment. If you compare the marked up version and the clean version, you'll see that the problem is a failure to change the numbering.
Okay.
But there's a match between what was left out and kept.
Okay.
So it's just the numbering that's off.
All right, then that's my own...
No, it was confusing.
That's my own failure, and I apologize for that. Other than that, I think what I have down here in section B, paragraph 5, I have a problem with the administrator having authority to determine jurisdiction. I think that should rest with the city attorney and then ultimately with the task force. Section C, paragraph 4, and paragraph 8. In the original copy, I put both of those in red because they're pretty much tied to each other. I'm wondering what sort of accommodations and what special circumstances being referred to. I think that should be spelled out. Section C, Section C8, paragraph 2 also declares what is to happen if a complainant fails to appear at a hearing, but it mentions nothing about when a respondent fails to appear, which could be a violation of 67.21E. Section C12A, I have a problem with the administrator given the discretion to delay hearings. I think that authority should rest with the task force or its chair. That's pretty much it. I'm happy to answer any questions.
Now a good time?
Yes, Member Pilpel.
Great. So thank you, and Rick, I appreciate the time that you have taken on this, and I suspect that we're going to take some time on this today, and perhaps in the future, regardless of what happens today, this will not be the last time the procedures will be before us. As to your couple of emails that I'm just seeing today, you had some concern about the portions missing. I think we just talked through that. But your other email, the one from Friday at 2:21, referred to the draft proposal in PDF and a list of my concerns thereto in doc. Is the notes document that's attached, is that, which one of those things is it? Is that the concerns?
I'm sorry.
I'm sorry.
I'm sorry. I'm not following you. Please.
Let me try that again in English.
Beg your indulgence.
The third page from the end in the packet that you've got, the email from 2:21 p.m.
Third page in the packet?
The handout from today. Can somebody?
Okay. This is...
Your email to Victor from Friday at 2:21 p.m.
Okay. Oh, yeah, that's my... You're referring to my email.
Yes.
Okay.
So it says in the text of it, attached are 1, the draft proposal in PDF, and 2, a list of my concerns in doc. The thing that follows it, the next page, are these, which of these things is this? The draft concerns?
Well, those are my concerns
Okay.
in the doc file.
Okay, so did you also mark up the draft proposal in PDF, and we don't have that here?
No. No, I just forwarded it to anybody, the PDF that was...
I just want to be sure that we have everything.
the PDF that's linked in the agenda. It's linked to the
so
agenda.
You're just sending that back?
Yeah.
Okay. So that's why we don't have it.
Yeah.
Okay. Thanks. I guess I don't have a problem with the typos that you found. I'm still thinking through the suggestions that you had, or the issues that you had. Did you have examples of the special needs circumstances or requests for accommodations? Do you think that should be in here, or are you just suggesting that we have some expanded verbiage and you weren't offering?
Well, no. What I am saying is that perhaps the task force should give some examples of accommodations and special needs or circumstances. So, I think the language itself is not really objectionable. It's just too vague for me. Somebody, a member of the public looking at that would have no idea what it means. And, but unless I'm underestimating the public's intelligence and imagination skills, but seems to me that there should be some, even hypothetical examples enumerated so that a member of the public would have some idea of whether he should ask for special accommodations or whether he has special circumstances, such as, for instance, asking for a postponement or a change of venue, or asking to be able to address the task force on a complaint by telephone,
Right, those are
telephone hookup. But I think that again, I think in the document there should be some kind of hypothetical examples listed, just kind of to make it clearer to your average member of the public.
What I'd like to suggest is that Mr. Young research what is mandated and what is possible here in this building. So, and maybe that could be enumerated in some detail and be an attachment to this, and a reference made to that document. I think, I'm not clear about what all is possible. I know we've had various accommodations in the past, but I don't know, number one, what's mandated, and number two, beyond that, what's even possible.
Yeah.
So would that be helpful?
It would, and Madam Chair, if I might, begging your indulgence, because I haven't been officially recognized, but it seems to me that in the past, when I was on the task force, we made special accommodation for people who wanted to complain anonymously, and we allowed them to do so by telephone hookup so that their anonymity would be respected. That kind of thing, just for one example.
Right, okay. So, Mr. Young, is it possible to do that research?
I intentionally left it blank. We discussed this a year ago, and it was intentionally left vague because I cannot guarantee what the building and the media services can do. It's best to take it on a case-by-case scenario.
Well, I think that should be explained then, that various types of accommodations can be made within the constraints of the hearing room. But I would like to see some clarification for the task force of this is what we're required to do by law. This is city policy, or these are the type of circumstances. These are the types of accommodations, and then have that, and then make a note that all of this is subject to change. Particularly the accommodations with new technology or so forth. Does that seem reasonable?
Madam Chair?
Member Pilpel?
I think the problem I have with this is that it cuts different ways. The more you explain, the more it sort of invites either more requests or more interpretation. I think if someone has a special need of any kind, if they communicate that in some fashion to Victor, he'll find a way to deal with it and either bring it to our attention or accommodate it. If it's an ADA request that we need to address, we'll find a way to do that. If it's some other request for timing or scheduling or anonymity or whatever else, we'll try to deal with that. Again, technology changes. We've had requests and we've done real-time captioning at meetings. We've done things by phone. We've heard things out of order. We've done all kinds of things. And I think where it's reasonable for us to accommodate it, whether it's for an ADA reason or some other reason, we'll attempt to, and in almost all cases, do that.
Well, I agree, except, on the other hand, if you don't give some specificity, people won't know that it is even possible for them to request
We could
an
add another
accommodation.
sentence, perhaps.
I can provide one sample that is not going to change, such as ADA accommodations, and please contact the administrator if you have other issues, and we can try to work with you, or something to that effect. Because I know ADA will not change, but I don't want to state exactly what we can do because it depends on the circumstances, and I actually don't make that decision. That is sent out to I believe, the mayor's office of ADA, and they determine what is required and what I need to do.
Depends on the person and their circumstances.
Right, okay. Yes, I think maybe mention.
I think, stating ADA, most people will know that is a special circumstance, and we would make accommodations for that. And then if there's other issues, they can contact me, and I will try to work with them.
Okay.
Or contact the office, and we will see what we can do.
So is it possible to also, in addition to ADA accommodations, is it also possible to mention accommodations if the complainant wishes to be anonymous?
That's at your discretion, but again, I don't know of any special rules in the city to allow for anonymity. That would be your own procedures to develop a procedure to handle that.
Well, this is an opportunity to do that. And I think if we enumerate that, we'll need to come up with something.
Well, the current language says that we'll accept anonymous. We've talked about whether or not we would do that.
Right. Okay. So if that's the case, then we have to indicate that we will work with the person to help him or her maintain their anonymity. Mr. Nee, do you have anything else or any Any advice here?
No, nothing other than what I've already put down.
Okay, all right. So, members, I don't know if
Public comment. If you wanna
We're still
continue with that.
with public
We're still in
comment.
public comment.
we're still, okay.
hear
All right.
Anyone else?
Mr. Warfield, you indicated you wanted to speak.
Peter Warfield, Library Users Association. You started out saying you wanted to leave some time for the folks to read the late arriving material, and I would very much appreciate if you would leave some time for them to read. My letter is 2 pages and about 750 words. Do you want to allow some time? I'd be happy to wait.
I haven't had a chance to read it. I've been talking most of this time, so.
So you started out saying you wanted to leave some time for the task force to read it, to
Okay.
read the materials. I would appreciate very much if you would give time enough for yourself and others to read the material before starting.
Okay,
if that's
all
what
right.
you'd like.
Let's take a
Appreciate
few
it.
minutes to do that. I for one haven't read it because I was talking.
Through the chair, perhaps we can take
Mr. Hyland?
other public comment at this point, just to make sure that everyone gets an opportunity to talk.
Is there anyone else who's here to make public comment on item number 2 regarding the complaint procedures? Okay, I don't see anybody else at this time, so let's take time to review this, and then we'll give Mr. Warfield 5 minutes to talk about it.
Up to 5.
Victor.
Okay, it looks like we're ready to move on. Mr. Warfield? You have 5 minutes.
Thank you, Madam Chair, and thank you for taking the time to read this. I'm a little disappointed. I sent this out about 6 o'clock last night, hoping it might be sent the same evening or first thing in the morning, and I'm told by your administrator that this was not emailed to you, but simply brought to the meeting room. But thank you for taking the time. I haven't mentioned a number of things. There's a lot to say, but I certainly think that you should reject these changes out of hand. They are toxic, and they're an assault on open government and on the public who seeks and needs to get justice and a fair hearing under the law. I'll just start out with a couple of things procedurally. Why did this not go to the Rules Committee? You have a Rules Committee, and that's supposed to hear changes. Why was this not listed as a bylaws change, including with the proper minimum 10 days notice? Because this is a bylaws change. It affects how you do your daily business, and it affects the duties of your officers and administrator. What is the history of this? We have no history here. What prompted this? What is the source? What are the changes? This appeared in February and then was supposed to come up in March, but it never did until September. Then it came up with a bunch of changes. I have been unable to learn from the administrator or the backup administrator yesterday details about where the wording came from, what is the problem or problems it's supposed to solve. There are also prior communications that were sent to you and given to you by myself, by Alan Grossman, and probably others that are not included here and should be. I have copies here in case anybody would like a copy of the document, but it sounds like you got handed copies. Is that correct, Madam Chair?
We all have them. Excuse me, DCA 3.
What? Should be the same copy in the same version that presumably you have been reading, but I would like each of you to get copies. I think that I'll read excerpts from my letter and certainly be glad to answer questions. To pass any of the toxic proposed changes would represent your betrayal of the voters and the public in the basic principles and purposes of the Sunshine Ordinance. I've also mentioned not only previous comments and communications, but the West Side Observer article that I wrote, New Complaint Procedures Defeat Sunshine, which I'm disappointed not to see in the packet along with prior communications.
It is there. It is in the packet.
The prior communications? Okay, good. The handout here then was just the latest, I take it, that wasn't included in the packet. Is that right? Okay.
Yes.
The overall stance of this is totally punitive to the public. You want to exclude and allow your administrator to exclude if a whole range of conditions aren't met. And the only place that that's determined in some cases is your administrator, completely in the dark, completely in secret. That is not public decision-making, but rather administrative decision-making. Instead of assisting the public to improve or clarify unclear or problematic language in the complaints, including somebody can walk into an office and know they went to this address and they spoke to the front office person. They might not know the exact name of the office. They might get the law library mixed up with the public library, and they might certainly not know the name. At the public library, they don't wear names. They have badges. If you can even see it, it has a number. We note that instead of assisting the public to clarify or improve unclear or problematic language in its complaints, the proposed rules represent punitive hurdles and exclusions. forced at times only by the administrator or so-called staff to simply exclude the complaints. There's a complaint exclusion if somebody hasn't been responsive to communications. What does that mean? Who is determining that? You're not considering the statutory requirements, which is above all important, which has time limits, and which these changes are smashing even more than you do at present. And I'd be glad to answer any questions. So I ask you to reject these out of hand. These are just toxic to the public and very one-sided.
Members, are there any questions for Mr.
Would you like to
Warfield?
close public comment at this time?
Is there any additional public comment? Okay, seeing none, the matters with the task force for discussion, possible action, questions
Through the chair. I was actually slightly offended by the tone of that piece by Mr. Warfield. I think questioning our integrity and using words like toxic makes it sound like we're, trying to shine less sunshine, and I take offense to that. I think we've done a good job. This charter has been 20 years. We're looking to reform it. We're looking for input from the public. I think what's much more productive is along the lines of what Mr. Nee provided, which is an item-by-item, sentence-by-sentence, word-by-word type suggestion, and I would invite Mr. Warfield to help us in that matter. I think that'd be much more productive, and we'll get where we're going to get. And I think it's going to take some time, obviously, to get these changes right, and I think we should take our time and do that, as a work in progress. Just a thought.
May I suggest,
Mr. Young?
we've done this in the past, but I can go through the proposed changes, and we can discuss them as we go along, because a lot of these items are not
Technical in nature.
they're semi-technical in nature, and some of them are just being changed to reflect our current practices.
Okay, I think what's being called into question, though, by both speakers is perhaps there's some problems with our current practice. So I think those are the things that we ought to consider.
Yes.
And I was listening to Mr. Nee in particular mentioned a couple substantive things. Also, Mr. Grossman had some questions about our current matter of using the complaint committee. Mr. Nee had an issue with that as well that I think it's kind of been nagging me. That's the way we're doing things now. We may be unnecessarily delaying things such that we're violating the 45-day rule. Not that we've ever adhered to it very well, but given our backlog. But we decided to implement the complaint committee to, hasten the pace at which we were reviewing complaints. And so there may be, I think we should look at the complaint procedure, the complaint committees, the way we're doing it now, to see if it can't be, first of all, clarified and then improved and address some of the concerns that have been raised.
Through the chair. Just to
Vice Chair Hyland.
Just to respond to that, I'm not sure if we can neatly capture those practice issues that the members of the public are bringing up in the 1 through 12 here, or whether that merits additional discussion before, or during, or after. But I think it'd be good to have some sort of framework where we work through and just knock off, like, okay, we're happy with Section 1, we're happy with Section 2, we're happy with Section 3, just to get some progress. Because I think if we just, I think so much of it is interconnected. If we just throw it out, we'll be here for hours discussing and have no real product at the end, and that's what I'm worried about. So I think some sort of structural approach is all I would advocate.
Member Pilpel.
Just a couple of general comments. I agree with much of what Vice Chair Hyland said. I think we've been working through this for a number of months, and I would say that the reason that it did not go to the Rules Committee, in my opinion, is that these are really our fundamental procedures, and they really require all of our input to get right. And even if we sent it to a committee for full discussion, we'd kind of repeat the full discussion right here, which is so.
Well, it's also, it has been in Rules, and it's not that it hasn't been. It just
We've
hasn't
spent some
been.
time there, and we're back here, and we still,
Right.
there's some things that we haven't quite hashed through, and we're going to do that now and in the future. What I've heard from a couple of members of the public in the written submissions is concern largely about how much power we're giving to the administrator.
Right.
And I want to address that for a second, if I might. I don't think that we're giving Victor, Andrea, anybody else who serves in that capacity any huge amount of power. Any decision or recommendation that they make is communicated to the chair and the vice chair for their approval or rejection. And if there's anything, my sense is if there's anything that's even on the edge, it's brought to us at the full task force, either in the administrator's report or in a separate agenda item, and a member of the public always has the opportunity to come here and say, I don't like the way I was treated on this, or I don't like that decision. And we hear that on occasion, but more often than not, I think we hear that when something is brought up, that Victor tries to address it and deal with it, and again, that the chair and the vice chair review all of those recommendations and decisions. So I don't think that there's some huge grant or delegation of authority to the administrator here, and to the extent that there's any discretion used, I think it's with the past actions of the task force, so as to not bring something back that we've already adjudicated, or to bring back the same question or the same kind of circumstance that we've already addressed, especially in recent memory. If it was something that we dealt with 5 years ago and we might deal with it differently, I think that might be brought back before us. But if it was the same question that we talked about last month or the month before, I think the administrator is going to use their discretion and say, no, the task force already ruled on that. And that's what this does.
Okay, no, I agree. Having worked with Victor for almost 2 years now, it is the case that he runs everything by me and Vice Chair Hyland, and communicates with us on a regular basis about matters. And sometimes I'm not sure what to do, and it comes to the full task force. But I think, though, that this document could be more specific about this, make this clear, that the administrator in consultation with the chair, or under the direction of the chair, is the one who actually does some of this. But it's simply not true that the administrator is making all of these decisions himself, unilaterally.
Okay.
Doesn't happen.
I'd like to suggest we try my methodology. After one or two, if it does not work, we can try something different. But if you look on page 9 of the complaint procedures, line 22, it says the administrator shall discuss requests with members of the public and attempt to mediate. I have removed the word with the assistance of the city attorney, because the city attorney does not help me when I try to mediate requests with the members of the public. Does the task force have any issues with that, or is it okay to make that change or that deletion?
Okay, these are instances where somebody is calling with a question or with a problem, and this is before a formal complaint is filed.
Yes.
It doesn't get to the complaint level. So you work with members of the public to obtain public records for them.
Yes, I do try to do that.
Okay.
I do make that attempt.
All right, so
Could I also add, it seems to me that it's implicit that if Victor needs Jerry's assistance or someone else's assistance, he would ask for that and get that. So I don't have a problem removing the city attorney from that line.
So, Mr. Young, what's your suggestion, and along the lines of what Vice Chair Hyland said, we're going through this methodically to try to clear up as many things as we
Yes,
can
and then
right
some
now.
of the bigger issues, after we make these changes, we can bring it back for additional amendments and address some of the bigger issues.
Okay.
It's too much to cover at one time. If we need to take some of these.
No, I
and
agree.
move on.
Yeah, there are also all the typos. I think I've gone through. I've added the ones that Rick Nee sent, and I will give you those.
Yes,
Anybody else? We can clear those up without any problems.
Yes, and once we get something a little bit cleaner, we can do a better check of it. There's just so many strikeouts. It is difficult.
It's striking.
Member Wolf?
So are we going through all of the underlines and strikeouts that are on that document right now? I'm just trying to understand exactly what we're doing.
That is my suggestion,
Okay.
to at least try to get some of these done in that manner. and then come back and attack some of the conceptual issues either later in the meeting or after we get through this once.
Yeah, through the chair, might we set a time limit on this item and just plow ahead and get as far as we can today and then pick it up as needed?
Yeah, that's, looking at the rest of the agenda, we have one hearing,
Yes.
and I don't want to delay that
I think
beyond
the parties
what...
are both here.
The parties are here. But I want to spend a good amount of time on this.
Could we check in 20 minutes and see where we're at?
Yeah, let's go to 5, and we'll consult with our people here for the hearing to see how much patience they have, and please, let us know if we're going way overboard. All right, so we're on page...
Page 9, line 22.
I suggest that what I'm doing is I have both copies, the clean and the marked up one, and makes it easy for me to see what's going on, so...
Yes. The first one is deletion of the words "with the assistance of the city attorney."
Because that's not how it's done.
That is not how it's done.
Okay.
Is there any objection to that change? There are no objections to that change. The next section is on the same page under B2. Under this section, I have listed the minimum, maybe not the minimum, but what I need to have in order to process a complaint form. The name of the department representative, if there is one, the complaint. I review it to be sure that it is a department that's under the jurisdiction of the task force. There are other avenues if there's a disagreement with that, but such as if they're picking a nonprofit agency, which we have no jurisdiction, I would not accept the complaint. Description of the alleged violation.
I think, sorry, on that third bullet, I think I'm better with the complaint is under the jurisdiction of the SOTF or the task force, because nonprofit things aren't under the Sunshine Ordinance. They're actually the nonprofits. It's a different ordinance. So it's just basically the task force's jurisdiction.
Under the jurisdiction of the task force.
Yeah.
We don't need to state that. We just...
Okay, now, we have had a comment from those who have reviewed this, members of the public who have reviewed this, stating that it is really the task force itself which has the authority to determine jurisdiction. This is something that we always determine before we have a hearing on the merits. So, but I realize there may be cases that are so cut and dry that it wouldn't make sense to bring them to the task force. But so I don't know. I need some.
There's language in here, and I think I did a version that I didn't bring with me tonight that had some better language about kind of contesting a threshold determination that the task force doesn't have jurisdiction and allowing a complainant to bring that before us. So, for example, if someone had a complaint about the federal government or Alameda County or the Golden Gate Bridge District, Victor would be appropriate to kick that out. If they have some argument about the housing authority, like we've had, that might be something that could be brought before us. And Member Rummold has.
DC 3?
Through the chair to the task force, if I might make a suggestion, one way to treat this might simply be to require that complainants allege what the basis for jurisdiction is under those ordinances that the task force administers. So, for instance, we've in the past had complaints that have come to the task force that involve state statutes that are not under the task force's purview. There's no real basis for the task force to hear those yet. They've come to the task force and there's been discussion over it. It's taken 20 to 30 minutes and then it's out. But that's 20 to 30 minutes that you could be spending on something that you actually do have jurisdiction to determine. That way, if the complainant alleges the basis for it, then there's some basis for the task force to make a decision. You might decide there's not jurisdiction, but at least there's been some basis to allege for it.
So I was wondering if we could have language in here, and I'm sure this is what you do in reality, Victor, is work with the complainant at all, for all of this. I mean, Mr. Warfield made the point, people who have never been through this process before wouldn't know what they need to have on hand to file a complaint. So I'm sure you work with them to help them
Yes,
craft a good complaint that we can actually deal with.
If they do not meet what I need, I do contact them and reach out to them and try to help them provide the information that I need to process a complaint form. And in addition, on the same on the next page, item 6 describes what jurisdiction is.
Right, okay, so I'm thinking I would like to, it might be a good idea to have some language in B2 there about that you'll work with the complainant to ensure that the complaint is complete. Also, maybe include that in the description that you hand to them. This is how this works.
Yes.
Make sure that the complainant understands that there'll be some help so that their complaint won't be tossed because they're missing some of this information.
Yeah.
I think that, I think that would address some of Mr. Warfield's concerns.
I agree. Through the
Vice Chair Hyland?
Yeah, just on that point, I think that particular sentence could be written in a much more welcoming to the public manner, such as the SOTF administrator shall review incoming complaints and work with the complainant to make sure they ensure that they fall within jurisdiction and
Are complete and include the following.
The following items.
Yeah.
are recognized as a complete complaint. Also, to talk to DCA Street's comment, I think it's hard to throw the onus of providing jurisdiction on the public, because again, they won't even understand that concept in many cases. So I'd much rather that comes from us, and that's in there saying that we'll work with you to make sure that we can do jurisdiction, and that this is a complete complaint. I think that gets us on a much better, footing, and that's the kind of, tone we should set.
Right, I agree. And we might even have something, if it's not the task force jurisdiction,
Just requirements or something.
you'll be offered some suggestions about where you might go with it. Member Wolf.
In revising these policies, I think we should be conscious of the fact that what works with Victor as our administrator should not necessarily be reflected in the policies, because we could end up with someone other than Victor in the future and a different task force in the future, and we'll still have the policy. So we should be sure that the language is consistent with having someone who may not actually be as supportive of the task force in that role of administrator in the future. And I agree around the idea of not putting the onus for jurisdiction on the task force. I'm a little confused as to why the second item, department representative, is listed there, given that many of the people filing complaints may not have a sense of who the right representative they're supposed to be putting down there would be. I understand the reason for needing that, but I'm not sure that it should be listed under the requirements in that form due to the onus that it puts on potential complainants.
If I might? I think
Member Pilpel.
just on that point, I think it says if applicable, and the reason is that if you're filing a complaint against the health department, it could be one of 5,000 people, and if you can indicate that you dealt with so-and-so, that will help us get to the right person. So it's only if they have the person. I don't think that would, invalidate a complaint, but it's like if they know the name, they should provide the name. That's all. I don't think that's a substantial burden on the complainant.
Right, and as you know, once we get into the hearing process, we often find other people who should be named in the complaint, not just
But at least it's a starting point.
the frontline person.
If they dealt with someone, that's all.
Yeah, Member Wolf.
I mean, my concern is not that shouldn't be in there, but the way it's written is that's a way that a different administrator down the road could toss complaints out the way that it's written. And so I just want to be cognizant of potential political futures in how we craft this.
Okay, so I think we want a document that's specific and that strikes the tone that we want.
Yeah.
That
Through the chair, I think if
Vice Chair Hyland.
and I can work with you on the language if you like for future edits, but We'll help you build a case is the message we want to send. Not we're going to disqualify your complaint because you didn't meet X, Y, and Z.
Right.
That's the tone I think that.
Yeah, you will be helped.
And sometimes writing, legalese or city hallese documents come out very formal and tight, and I'm guessing it's more a situation with that than it is that we're, trying to make this toxic or hard for the members of the public. That is not our goal. Quite the opposite.
So we will rewrite Section 2 and bring it back to you. The third item is a very simple one. It's a simple statement so that the members of the public know that anything provided to the Sunshine Ordinance Task Force are considered public records. And if they wish to remain anonymous, we do write this in our application too, that we will not redact anything provided to us.
We're on B3?
Yes, B3. That is stated on our application form that we will not redact documents provided to us.
If I may.
Member Pilpel.
And I think there's a numbering problem here. I think 4 seems to have disappeared. I'm still not crazy about anonymous complaints, but if that's the direction we're going for the moment, I'm not going to go nuts about that today. On the statement that we will not redact submitted documents, I would just add to that, except as required by law. So if we get a submission from either side that includes a Social Security number, I think we kind of have an obligation.
I believe that would just be office policy and it does not need to be written into a...
No, I think it should be our policy because I think we decide how the files are handled, and I think we should be sensitive to those things. I don't think we should go out of the way if somebody's got email addresses to try to go nuts with that, but if we are dealing with an employee file issue and there's a social on there, I think we kind of have an obligation.
If we go that route, I'll need to ask the task force to develop their own redaction policy.
Okay, then we need to get the office's redaction policy, and we'll take a look at that and incorporate it or revise it. I'm just wondering if DCA 3 has a comment on our legal obligation there.
I think if we just change it to, please note that the SOTF may not always redact. Well, that doesn't come out right either. I think if the member of the public looked at that as it stated, it states that the SOTF will never, ever redact submitted documents.
Right.
And that's incorrect. Right. How are they to know that there's another governing policy that would affect that? So I think if we either, as Member Pilpel suggested, with respect to current law, or put something a little more clear, not so absolute there.
Maybe DCA 3 has some thoughts now or in the future.
Right, yes. You wanted to speak earlier, sorry.
Through the chair, if Member Pilpel has questions, I'd be happy to answer them. I was not offering to make comments, but I'm happy to answer questions.
If we included the language, will not redact submitted documents except as required by law, would that be a better statement in our policies?
I think that, through the chair, I think that would more accurately reflect what would need to happen. Yes.
Thank you.
And I think that would be reassuring to anybody who wanted to
May
remain
not be the final answer,
anonymous.
but I think it's better. And
Okay. Member Wolf.
So this item is specifically about anonymous complaints and the redaction therein. So what if instead of, hearkening back to our legal obligations of redactions, we just focus on the anonymous side and say, the SOTF will not redact submitted documents to protect anonymous complainers, so that we're addressing the fact that we don't redact documents that this person's identity may be exposed in, and so we're keeping the whole item encompassed in the item as opposed to invoking this redaction policy that goes far beyond that item.
that makes some sense, actually. I can deal with it.
Yeah, we could do both. We could make it clear that we're not going to do anything beyond what they've done to maintain their anonymity. However, there will be redaction of material if mandated by law.
I mean, for example, we've gotten complaints where the complainant said, I wish to remain anonymous, and yet they submitted underlying documents that identified themselves.
Yeah.
So, and then show up at the hearing and name who they are. So it's like they can be anonymous to the extent that they choose to be, but if they're going to let everyone know who they are, they
Yeah, we're not the whistleblower program,
Right.
for instance.
Right.
Don't get me started.
Yeah, I know. So, through the chair, maybe we can
Vice Chair
incorporate
Hyland?
both of those thoughts as provided by law or as provided by the anonymous complainant. Get that language in. So we will work to maintain anonymity as provided as regarding redaction as provided by the complainant and applicable laws. Language of that effect, maybe.
I believe we slightly addressed this on the next page, 10, line 1, with the missing item number 4. The SOTF will accept anonymous complaints. However, please note that the SOTF will not redact submitted documents.
That's what we're talking about.
Okay.
Yeah.
So it would
Yes.
add language at the end of that sentence. Something like beyond what's submitted by the complainant or as otherwise required by law. Something like that.
All right.
Or documents submitted by anonymous will become public documents, just to let them know to...
That's in there. Yeah.
That's,
before that
says that.
Okay.
Member Rummold?
So I'm in favor of just adding the part about to protect anonymity instead of the as required by law, because we ran into this circumstance earlier, and then I don't remember when it was, where a complainant had submitted someone's name, and then we redacted the name from the complaint, and the police officers union was saying, oh, this is required by law, and it was eventually redacted. I actually think that was improper on our part to do that. So I think, I mean, I guess I could see a situation where we get a social security number or something and we decide in our discretion that we need to redact it, but I would prefer that we be like a passive vessel for the documents that we receive and the other agencies do the redacting, right? And it's not our responsibility or the administrator's responsibility to review those documents and ensure that all information is properly withheld.
I think we're talking, though, not about what agencies give that affects someone's anonymity, but what the complainant provides, and the complainant...
Well, sure, okay.
And we're not going to redo their redactions, but if they happen to give us something that's not disclosable, then I think we need, it's...
Well, I don't know. I can't imagine a circumstance where a complainant would provide something that they knew was going to be a matter of public record and to be published, that we would then have the authority to censor. That's what strikes me as
They could have gotten a police report in their individual capacity, which reveals some third-party stuff that others wouldn't. And I can see circumstances where a complainant might provide whether they knew or didn't know, and that there might be some other obligation. But I don't want to get too far down to that. Maybe you're right, and we should just limit it to, we'll not,
Through the chair.
do it any more than the.
Vice Chair
I was
Hyland?
just going to say, perhaps if Member Romo might want to take a stab at that sentence, and just so it's on the record, and we can come up with a derivation.
I thought what Josh had was good.
Okay.
Okay. Member Wolf?
Yeah, I guess I'm just sort of going back to the fact that if we say that we will, redact information as required by law, there are issues such as like the ramifications of the Police Officers Bill of Rights and that situation that came up that these things would need to get parsed through someone that isn't Victor in order to ensure that happened. And if it's in our policy, then we've created a violation of our own policy inadvertently sometimes, whereas obviously when it comes to security numbers, we should exercise our discretion. But putting that in there, I feel like opens the door to then someone like potentially suing the task force for violating its policy. Yeah. And all of this that just makes me a little nervous.
Actually, through the chair, just listening to that, why can we just not write the SOTF will accept anonymous complaints, period? No second sentence. Do we have to address that? drop the redacted submitted documents reference. Just, we will accept anonymous complaints, period. And
Sort of, I don't know. I
Because
think it
again-
sort of begs the question.
well, as that anonymous approaches Victor and brings up complaints, then Victor, whoever the clerk is, would then address, okay, you realize this is going to become a public document, just
Well, why don't we just say that, though, in the policies?
to Josh's point, I'm trying to, is that appropriate in our policies, or is that something bigger and outside of this narrow, or this scope, I should say? I don't know.
I'd like to sit with the Josh approach for the moment. I think I'm getting with that.
We can try to write something, and we can come back to this at a future meeting.
Josh.
Okay. I want to observe that it's 5 o'clock. We haven't gotten very far. Do we want to get through down to C at the end of B? Why don't we do that? And then it shouldn't, it could take us a while, but
The next one is authorizing the chair, officially authorizing the chair or his or her as a representative to combine similar complaints, assign hearing dates, and reassign complaints to and from committee in an effort to manage the workload pending before the Sunshine Ordinance Task Force. In this statement, we should probably also indicate if the task force would like to combine files for hearing when multiple items from similar subject matter are scheduled before the Sunshine Ordinance Task Force for hearing.
one thing that I noticed with this was reassign complaints to and from committee. I think we should specify the complaint committee.
I think it's beyond that. I think the idea, if I understood from our previous discussions, was that when we're sending something to review for compliance
Oh,
at
okay.
DOT or
Right. This is
CAC,
bigger-
and there's
bigger.
a related new complaint, that we would send the related new complaint to be heard along with the old thing because it's sort of a continuation of the similar subject matter. But there may be other circumstances where it makes sense to move things for workload or similar subject, whatever. And this is just saying that you guys have the ability to sort of manage our workload.
Right. Okay. I was.
As we have done in practice the last.
No, I know. No, I'm sorry. I was thinking more narrowly.
And I think maybe Victor's comment about adding another sentence about when items are likely to be heard together so that complainants and respondents are notified. I'm not sure that that's the right place for it. I think it's somewhere in C.
Yeah,
because it's really related to the hearing itself rather than the scheduling.
Yeah, I agree with that. I think that's something we talked about adopting going forward, and I think we really should because it's, fair notice to all parties.
Yeah.
Okay.
And
Any
through
other?
Through the chair, am I right in thinking that would actually be 4 and there is no 5?
The clean copy shows that as number 5.
I believe number 4,
Number 4 is
missing. The SOTF will accept anonymous complaints. It's on page 10, line 1. The numbering number 4 is missing from.
Oh, I see. That should be number 4. Got
Yes.
it. Okay. So we should put that in too.
Actually, I think it just gets renumbered. So what's now here is 5, 6, and 7 become 4, 5, and 6 in the clean copy.
Yeah, the clean copy is cleaner.
Yeah.
So the numbering makes
But
sense.
think about the text. The numbering will. Yeah.
Number 6, which is, it's 6 on the clean copy, 7 on the marked up copy,
This becomes.
beginning upon filing a complaint. This is referring the complainant.
This is a
to the-
relatively simple change. I added the line, failure to respond to a SOTF complaint and/or failure to provide requested documents may lead to a violation of the Sunshine Ordinance. This is a simple statement stating if they don't respond within 5 days of our request, of our referral to the department. Let me start that over. When we refer a complaint to the department, we request that they respond to us within 5 business days. However, this is a simple statement that we may find a violation if they don't meet that deadline.
Right.
And we have deleted the section regarding the deputy city attorney who advises the city departments may assist. That's in the Sunshine Ordinance, and I don't believe it's needed here at this time. And then one additional added line, a copy of the complaint shall be sent to the chair of the task force and the deputy city attorney representing the task force.
Right, and that's what we do. Mr. Nee had something to add there, in that the failure to respond to an SOTF complaint and or failure to provide requested documents may lead to a finding of a violation of the Sunshine Ordinance. I have that part of my markup too.
I just had two things, and then I think maybe we'll reassess where we're at. I know that several of the commenters had an issue with what's in the marked up 6 and the clean copy 5, the ability to review a complaint to determine if we have jurisdiction. It's that jurisdiction thing again. I think this makes more clear, and this is probably the language I was looking for earlier, that where someone disagrees with a threshold determination about jurisdiction, they can contest that with the full task force. So I think that language is good, and I don't...
You mean the second bulleted point?
Yeah. So even if we tell them to, whatever, if they have an issue, they can bring it before us. There's certainly an avenue for that. And then I still have, I guess I have a concern with line 23, 24. This failure of a department to respond within 5 days may lead to a violation. Remind me, what violation would we find? Is that, I'm not sure that there's a 21E
It's
requirement.
never been determined what a violation of our request would be.
Right, yeah, I can't remember us. I mean, it probably happens frequently where they don't respond in time,
don't
right?
respond in time, or in some cases don't respond at all. There's a 21E requirement that they either attend or explain the basis of their reason, but I'm not sure that under the law that we can force them within 5 days to get back to it. Am I missing something?
Through the chair of the task force, there may not be a specific basis to find a violation for failure to respond, but the effect of the failure to respond is that you're not providing any defense.
Fair enough.
And whatever was the alleged violation, the task force is free to find that those violations are valid.
Okay.
And impose them against it. So it really would depend on what the complaint was, what the actual violation would be found.
Okay, so it's more of a failure to defend than anything.
Yeah.
Okay.
So if someone alleges a violation of 61.21 for failing to provide public records, they don't show up, task force is likely to find there was a violation.
Okay. So maybe Rick's language is right, may lead to a finding of a violation.
Right.
Okay. All right. I'm good with that.
Anything else before we move on to general public comment? And then we I guess...
To the chair. Could we,
Vice Chair Hyland?
is it possible we could pause this item and then revisit it depending on how the agenda moves later? I mean, that might inconvenience members of the public, but at least we get some more work done on it.
Yeah, it's...
We can
yeah.
pass and retain, as it were. Yeah.
Yeah, I would be up for that, depending on how the rest of the meeting goes. Member Wolf?
I know we're not getting to this section yet. I just want to log it for the record. I'm confused about the word consensus that comes up later on in this document in section C somewhere. I don't know whether we've defined consensus, and I think a decision by the group is better, or decision by the task force or committee is better than consensus if we haven't defined consensus.
Thought there was consensus on the meeting and consensus. Okay. Mr. Young, would you call item number?
Yes, at this time, we are going to delete any additional action on item number 2, and we may take it up. We will take this up at a later time during today's meeting.
May.
We will, since we will at least need to continue it, or we will take action on it later in the meeting.
Fair enough.
All right.
Next on the agenda. At this time, it is 5 o'clock, and we will be moving to item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the Sunshine Ordinance Task Force jurisdiction, but not on today's agenda.
Good afternoon again, Richard Nee. What I'm about to offer is not within the task force's jurisdiction, but I think it will be of interest anyway, and I beg your indulgence, and I hope I'm not stealing any thunder here from Member Eldon or Member Rumold. The Society of Professional Journalists Northern California chapter is calling for nominations for its annual James Madison Awards, honoring champions of the First Amendment and freedom of information. The deadline for nominations has been extended a week, so it's now Friday, January 15th. You can get more information at the website www.spjnorcal, that's spjnorcal.org. And the James Madison Awards dinner will be held on the evening of March 10th at the City Club in San Francisco. Hope you'll be able to attend.
Thank you.
Yeah.
Sir, Member Pilpul?
To Rick, I don't see him in the room right now, but I think I saw Michael Petrellis earlier. You might want to think about him as a potential nominee for his work in the last year on department head and Board of Supervisors calendars.
Thank you.
Thanks.
Is there additional public comment on items not before us this evening?
Good evening. Peter Warfield, Executive Director of Library Users Association. I do think it would be helpful if you would tell the public what your plan is for discussions of these changes that you have been discussing. In past passes, there has been public comment episodically throughout, so that, for example, each section or each item would be offered for public comment as it comes up. I would certainly recommend that. But whatever the case is, I think it would be helpful for yourselves and the public to understand what your plan of action is. I'm also a little confused about what's a clean copy and the numbering scheme. I thought I got the latest thing in the packet, and then I discovered that 5, 6, and 7 are misnumbered, and I don't know if there are other changes. I would certainly note that there were changes between the February appearance of the complaint procedure and bylaws change.
Excuse me, Mr. Warfield, this item is on our agenda.
The procedure that you're going to follow in pursuing it is not on the agenda.
Everything related to it is in that item.
Last month, there was a
Go right ahead.
supposed hearing on 2 complaints that Library Users Association filed, and it didn't follow any documented procedure at all. It apparently followed proposed procedures that, to my knowledge, hadn't been discussed and certainly hadn't been approved. So our 2 complaints were put into the administrator's report, no mention in the agenda, and there was simply a general statement that the issues or matters dealt with in the complaints had been previously dealt with. There were 2 prior complaint numbers cited. One of them was a complaint we had withdrawn. And at one point, Member Highland said that with respect to a complaint about a memo from the library, we've seen that memo. He was right. You have seen that memo, but that memo was contained as an incidental part of a complaint we had withdrawn and was never heard here. So I think that's very problematic, and from my perspective, it was just simply tossing 2 complaints without having a proper hearing. that's certainly something that you should consider as you go forward with your complaints and complaint procedures. Thank you.
Thank you. Is there additional public comment for items not on the agenda tonight? Okay, seeing none, Mr. Young, would you call item number 3, please?
I like. Yes. Item number 3, file number 15141, complaint filed by Michael Anderer against John Gavin and the Office of the City Administrator for allegedly violating Administrative Code Section 67.7 by failing to post the committee's Central Market and Tenderloin area agenda for October 1st, 2015 in a timely manner. The complaint committee recommended that the task force find a violation of Administrative Code Section 67.7 for failure to post an agenda in a timely manner. There was additional proposed violations. However, after going through them individually, this is the only violation that the committee found.
Member Fisher, do you have anything to add to fill in some of the details for the
Yeah, I don't think any of the people are here, are they, Mr.?
They are not here.
Yeah.
However, I believe they were, during the meeting, they were in agreement, and they departed cordially and agreed to work with each other in the future to make sure no additional violations occurred in the future.
That's pretty much all I was going to say. It was the complainant was from some school, and they didn't get the information they wanted, and then they were the only people here, so we said, well, talk to each other, and they kind of sorted it all out, and I think we gave that violation just so we'd have a record of it. It was really more in record only, so there wasn't really much else to say or do with this one, unless members Hinsey or who was my other person there that day?
Her call.
Member Eldon.
Was Member Eldon have something? Sorry, I lose track. Everybody on my right looks the same. Unless you have anything to add. I mean, it was pretty straightforward.
I just had one question. I was reading, again, I'd already seen the complaint committee recommendation, but it's on the second page of that. It's page 35 of our packet, and it's the next to the last bulleted point regarding posting of the minutes in a timely manner. And so it wasn't clear from my reading of this whether or not the minutes were posted in a timely way. The complainant didn't request them, the draft minutes, and the committee recommended or asked that they be posted online for convenience.
Yeah,
of the
if I
public.
recall, it wasn't part of his complaint, so we weren't going to go looking to add things to it. Does that sound about right?
I
No?
defer to your opinion. I don't recall.
That's, for some reason, I'm recalling that we kind of found that and said, hey, you're supposed to do this within 10 days. And then the complainant said, oh, I didn't have a problem with that. And we're like, well, yeah, but we still want this to be done. And the respondent said, yeah, we're going to work on that, or something to that effect.
Member Pilpel?
I just had 4 brief points here. On the first bullet on page 35, and I guess throughout, I think we should be clear with Mr. Gavin on the exact name of this thing. I think it's the Central Market and Tenderloin Area Citizens Advisory Committee. I think this is the entity that deals with like the Twitter tax break and blah, blah, blah. But we should get the name right. That was 1. 2, in the second bullet. I was not at the meeting, but I suspect from the later text that it should read on the second line, as Mr. Gavin indicated, that he did not receive the supporting documents with enough time to post it online. So we should check what was said, but I suspect, based on the rest of it, that he did not get the stuff in time. Otherwise, he would have, or whatever, and et cetera, et cetera. So that was 2. 3, when the final order issues, I think we should add Naomi Kelly to the list as the city administrator, because ultimately it rolls up to her. But John Gavin is certainly the representative there. And finally, what was the finally? I'm sorry, I can't remember now. I'll get back to you.
All right. Is there any further discussion? Is there a motion to?
Oh, and there's no referral. I think
It was really.
it sounds like you worked through it, and that's it. So
I was going to ask
It was
if you
just for-
thought this
no.
needed to go to EOT.
I really don't think so.
Okay.
Yeah, thank you, Fiona.
Okay. All right. Is
And I
there-
guess if we check with Mr. Gavin, I think he got reassigned since this thing happened. So whoever is continuing to staff the committee should have access to whatever to get the thing done on a timely basis.
Through the chair, if I make a motion
Vice Chair Hyland.
to accept the planning committee's recommendation and with no referral.
Is there a second?
Second.
Is there any public comment on the motion to accept the complaint committee's recommendation? Okay, seeing none. Mr. Young, would you call the roll on this motion, please?
On the motion to accept the recommendation of the committee, Member Rummel.
Aye.
Rummel, aye. Member Eldon.
Aye.
Eldon, aye. Member Wolf.
Aye.
Wolf, aye. Copra absent. Member Pilpel.
Aye.
Pilpel, aye. Member Haynes.
Aye.
Haynes, aye. Member Fisher. Aye. Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. The motion passes.
Mr. Young, would you call the next item, please?
I'd like to call item number 5 and 6 together. File number 15129, complaint filed by Joe Warren against Freya Horn and the Sheriff's Department. And item number 6, file number 15134, complaint filed by Joe Warren against the Department of Public Health. I did receive a request for continuance from Mr. Warren 5 business days prior to the meeting. Therefore, pursuant to our procedures, the continuance was granted. I just would like to note that for the record, I did not have time to remove it from the agenda today. And I am working with both parties to reschedule the matter at this time. I do not believe we need to take official action on this matter.
All right. Would you call the next item on the agenda?
Item number 7, file number 15159, complaint filed by Tom Borden against the Recreation and Park Department for allegedly violating Administrative Code Section 67.21 by failing to respond to a public records request in a timely and/or complete manner in regards to signage in lands managed by the Natural Areas Program.
Madam Chair?
Member Pilpel?
I should just state on the record that I have met Mr. Borden. He has talked to me not about the specific complaint, but about sort of general issues with Rec Park and signage. I have not reviewed the merits of the complaint nor discussed it with him, but I certainly am aware of Mr. Borden, and he knows me, and I just want to state that on the record. I don't believe it'll prejudice me in the action.
All right. Okay. First, we have to determine jurisdiction on this matter. Do I hear a motion to find jurisdiction? Would somebody please
So
make a-
moved.
Okay. Is there a second?
Second.
Okay. Is there any public comment on jurisdiction? Seeing none, without objection. Okay, at this time, Mr. Borden, you have 5 minutes to explain the situation here, why you're bringing this complaint.
Thank you. No. All right, I'll just read it. I was warned about that. So I sent you a lot of information. I filed a sunshine request. It had 3 parts, and I got responsive documents to 2 of the parts. But one of them was about the signs that were put up in natural areas and in the parks that said no bicycles, and we wanted to find out who put up the signs and why did they put them up. And so the middle part of my request was, basically who decided to put these signs up and why, and any documents related to that decision-making process. And I received nothing in response to that, so that's why I'm saying that the basis of my complaint. And the pieces of evidence I have to offer are, one, there was a paper written by Anna Alvarez, who's the Parks and Open Spaces superintendent, she wrote it after the signs went up and people began to complain. But she says in there the language for both signs referring to the park hour signs in natural areas and the regular parts of the parks was vetted through a review process inclusive of staff participation from operations, capital, and public affairs, as well as a review of existing regulatory guiding documents, i.e. park code, SINRAMP, et cetera. So there's a statement by an official in Rec and Park that there is this what seems like an extensive process, and yet there's absolutely no documentation was produced related to that process. Seems to me something is fishy there. The second thing I have to note is that in terms of the production of documents, most of it was email, and I received from people within Rec and Park 86 emails that were sent to Lisa Wayne, the head of the Natural Areas Program. She only produced herself 18 emails that she received. So it seems unbalanced. So again, that's other people sent me 86 emails that had gone to Lisa Wayne. She only produced 18 emails that had gone to her. In terms of emails sent by Lisa Wayne, 40 were produced by other people within Rec and Park. Lisa Wayne only produced 5 emails. So you would think that all of these would be mirrored. So it seems clear to me that a lot of Lisa Wayne was not providing quite a few emails. The other thing that's interesting is that RPD staff produced 11 emails they received from Phil Ginsburg, and he also received quite a few emails. I didn't count all of those, but he produced no documents in response to this request. And Sarah Ballard, Director of Public Policy and Public Affairs, and Denny Kern, Operations Manager, also sent and received quite a few relevant emails that I got from other people in Rec and Park, and neither of them produced any documents in response to this sunshine request. So it seems pretty clear that Phil Ginsburg, Denny Kern, Sarah Ballard, were sort of above this thing, and not to be troubled by producing any documents, and that Lisa Wayne was very, not very forthcoming. The other thing I'd like to say is that they said there were no documents that lead us to the decision making about who decided to put these words on these signs, and yet. Priority Architectural Graphics, the contractor for these signs, somehow got the information to what to put on these signs. There was a contract that wasn't produced, and someone instructed them what was going on these signs. So obviously there's some information somewhere that would lead back to who made the decision. I guess the one other point I'd like to make is that there are also 6 other emails that I collected from people outside of Rec and Park that had gone to Lisa Wayne that were very responsive documents that she did not produce. And one of the things that was reported to me by Rec and Park in response to this was I was referred to, again, I'll refer you to our records retention policy. Note that calendar records don't have to be retained except for those of the department head, in which case the retention period is 2 years. At any rate, I'm thinking it seems to be some argument that if you're not required to retain something, but you have it, you don't have to produce it. Thank you.
Thank you. We may have questions. We'll undoubtedly have questions for you in a bit. Is there anybody here to offer facts and evidence in support of the complainant? Okay. You're speaking in support of the complainant?
Yes.
Okay.
My name is Alex Aldrich, and I also had a sunshine request previously against Park and Rec, and my most recent sunshine request was just in regards to whether it was a rule or a regulation in regards to no bikes being on trails, because that's what Phil Ginsburg said in his letters, that there's long-standing regulation. And he said, well, it's not either a rule or a regulation, it is land management. And he's consistently changing his position based on whatever's someone telling him what to do. And with Tom Borden's sunshine request, that's just him just changing everything according to where he could just diffuse the situation and extend it out longer. I would really think that Phil Ginsburg, who was a lawyer at some point, knows the difference between kind of like tooling out his own laws versus actually listening to the San Francisco Park Code and the San Francisco Charter. And I don't think that he is doing his position very honorably at this moment. Thank you.
Thank you. Is there anybody else here to offer facts and evidence in support of the complainant? All right, at this time, the respondent, you have 5 minutes to respond.
Good evening, members of the task force. I'm Eric Pulowski, Recreation and Park Department. Thank you. In response to Mr. Borden's request, the department provided all responsive documents in its possession. We withheld nothing, we excluded nothing. Beyond that, I really don't know what more I can say.
All right, is there anyone here to offer facts and evidence in support of the respondent? All right, now the matters with the task force will have questions for both parties. Members? Member Pilpel?
So we've been over some of this territory in our previous complaint that we heard from Mr. Aldrich. In fact, we got a response from Rec Park in our packet that we'll talk about, and then when we get to the administrator's report, which I think is a little off what we were pointing out. Question to Mr. Pawlowski. Several things, if you could join us. In his comments or in the written submission, it looks like Mr. Borden asked for the department's record retention policy and schedule. Did you get that to him?
Yes, I did.
Okay. Is that on the department's website somewhere?
Yes, it is.
Okay. Can you show me where sometime? Because last time I looked, I couldn't find it. Is it somewhere intuitive under About Us or?
I'm happy to work with you to locate it.
Okay. We can figure that out. He has pointed out that he had some internal emails that he obtained from some other source or some other way that he didn't get from you through this sunshine request. Am I understanding that correctly? Join us for a second. I thought I understood it. Maybe I didn't.
What I said was, you're taller than me. What I said was that, that, like for instance, there were 86 emails provided to me with this that Eric produced that came from Rec Park employees. There were 86 emails that were going to Lisa Wayne. And there were 18 emails that Lisa Wayne produced that went to her. And then I said there were a number of other emails, much smaller number that I collected from outside of Rec and Park that had gone to Lisa Wayne that were very relevant, but somehow she did not produce. And maybe she didn't have them anymore. I don't know.
I think that's what I thought I heard. Okay. So if there were emails that Mr. Borden obtained some other way that weren't produced through your search with Lisa Wayne, can you account for that discrepancy?
I cannot. All I can tell you is that each employee within the department manages their inbox differently.
Differently? Do we not have a similar approach to records management pursuant to the record retention policy and schedule? Or
no employee of the department willfully violates the records retention policy.
Are they all similarly trained on how long they're supposed to keep stuff?
They are.
Okay. Did you happen to talk to Ms. Wayne on this point and determine how long she keeps and how she keeps her stuff and whether it's in a folder or whether it's all in her inbox or how?
I did not know. I didn't get into that level of detail in terms of management, but I did talk to her, and she assured me that she provided all responsive documents in her possession.
Okay, so I'm sure she provided all the stuff that she has, but the question is whether there were documents that either exceeded the record retention policy or were otherwise deleted and that didn't get produced as part of this round, and that's concerning, potentially. So I would ask at a minimum if you could follow up with her, and it sounds like she is kind of a key person on some of these issues, and it's probably a better idea for her to err on the side of keeping stuff longer or keeping stuff where there's, a question as to whether or not to keep it, because issues about whether it's, bikes on trails or other things involving the Natural Areas Program have been rather controversial. And, what she had and when she had it is probably pretty relevant.
Your opinion is noted, Mr. Pilpel. I'm happy to take that feedback back to her.
Okay, let me defer and I'll think of another thing. Thanks.
Member Wolf.
When you did search for, or when your staff searched for the emails, they used the search terms provided in the given public records request, I'm assuming. Is that correct?
We followed Mr. Borden's instructions. If you look at the original request, he basically gave some broad search terms that he was looking to guide us with, and then if that resulted in a field of documents that was too broad or irrelevant, he made some additional suggestions.
Great. And then I have a question for Mr. Borden. So obviously your request may have documents that were outside those search terms, but just for the sake of understanding what happened right now, the emails that you obtained third hand or second hand as opposed to from Ms. Wayne, do those emails that you feel you should have obtained from Ms. Wayne include the search terms you included in your public records request?
I think so. I'd have to look, but I think it's pretty telling that the other employees within Rec and Park thought they were responsive documents, and that's why I received them.
I would agree. I would just like to try to better understand what's going on. If those search terms aren't there, that may have been a path that she only searched under those search terms, and perhaps expanding the search is the best path forward. If they are in the search terms, then that means that either she didn't send email that she had or that she had gotten rid of those emails. So identifying where the disjunct occurred may be helpful in trying to get you all the records you need.
Right. Okay. I mean, I would have to go in and look at them in detail to figure that out.
Sure. Understand.
I had a follow-up.
Member Pilpel.
To Mr. Pawlowski. So it sounds like obviously there's some disagreement in the world about this policy. We've heard something about that. One of the issues seemed...
When you say policy, you mean the bicycling policy? Or
yes.
Okay.
And one of the issues that I've heard relates to the signage, specifically the signs that were put up that say no bicycle riding here or whatever they say. We don't have those right in front of us today. I think I understood from Mr. Borden's request in the packet that he was asking for essentially either the contract or the work order for those particular signs. Did I understand that correctly, Mr. Borden?
I was only suggesting that it would have been a responsive document.
Okay, thanks. So to the extent that it might be a responsive document, did you look for the specific order or invoice or work order for the particular signs at issue?
There were some financial documents concerning the signs that I did not provide. That it was at the purchase order level, because it wouldn't have come up. I didn't see how that was I didn't think Mr. Borden was looking for that. I'm happy to provide it. It's actually public information. It's posted on the Controller's office.
Okay. If you could provide that, I think that would be good. It may or may not be helpful, but let's try.
I would suggest it's not, but happy to provide it.
Okay. Well, let's say that the department paid to get signs put up, and that there is some purchase order that.
And there were some documents. There was an email chain in the documents, and there was some emails of a back and forth between the contractor, and there was some cost data. But the actual purchase order, I do not think I provided to Mr. Borden.
Okay, is the purchase order the document that would say, we would like you to put up a sign this big that says this on it?
No, it's not. Actually, the emails that we did provide them did provide that information.
Did?
I can tell you for a fact. Yeah,
Okay.
it's on the website. On the FDP website, the documents are all there.
So is it clear from those documents who placed the order with the specific language?
I'm not sure.
Can I ask Mr. Borden that?
Really quickly before, though, the person who purchased, our purchasing manager would make the purchase. He has no, he wasn't involved in the policy. Just
Okay, but it sounds like Mr. Borden was trying to figure out who was in the decision loop. If the purchasing person said, let's get the signs,
Right.
presumably they were doing that at someone else's behest in the department.
Two very distinct functions: the decision to purchase, the decision to put out a purchase order, a contract for the signs, and the actual mechanics by which those signs are purchased.
Okay, so who then in the department would make that choice to get the signs and have them put up, aside from the mechanics of making that happen?
We have no documents responsive to that question. I can just tell you that Phil Ginsburg is the general manager of the department, and he's the person accountable.
Right. I don't want to have the same discussion we had the last time on this. I think what I understood is that Mr. Borden is trying to figure out somewhere between Phil Ginsburg and the ground squirrel who made the choice to get the signs put up, and there ought to be some trail, sorry for the pun, some way to figure out who made that choice that wasn't the purchasing manager, but was somebody presumably in operations or policy or somewhere elsewhere within the department. How does one figure that out?
We don't have any documents that specifically line out that process.
So how would one figure that out? Forget the documents. Just tell me person to person if you wanted to go back and figure that out. It wasn't that long ago. It wasn't like 40 years ago. How do you find that? How do you figure it out?
I honestly, I couldn't tell you. I mean, I don't see a way. Let me rephrase that. I don't see a way through. I don't know. You're more of an expert on the Sunshine Ordinance than I am. All I know
but
is.
forget the Sunshine Ordinance. How would you figure out?
I'm not going to do that because that's not. I mean, here, this is a Sunshine Ordinance.
Put the ordinance aside for a second. How would you figure out within the department who might have made that choice?
Mr. Bilfil, I'm not going to accept the limitations on my comments that you're placing. This is a Sunshine Ordinance discussion.
Okay. So within the framework of the Sunshine Ordinance, how would you figure out?
Can I ask a question?
Sure. Okay.
Member Rummel.
So let me get this straight. You were saying that there are no documents that, out of all the documents that you produced, that are responsive to the second item of his request.
No, that's not true. That's subjective. I believe that there are several documents we provide that's responsive to that.
Can you show, in the documents, can you direct us to some of the documents that you think are responsive to? Because
not here and now, but sure, I'd happy to go through them and show you.
Okay, I think that would be.
I don't have. I mean, it's a lot of information. I don't have everything in front of me, and I can't recall everything perfectly. But there are documents in there that are responsive to item number 2 of Mr. Borden's request.
Which I think was what Member Pilpel was asking you was, if there are in fact documents that are responsive to the second part of this request, then that is some evidence of how the decision was made.
Right. And so to my earlier commentary, there were emails discussing the posting of the signage, and I would submit that those are responsive to number 2.
I have a question for Mr. Borden. So, given all that you've been able to obtain, however you've been able to obtain it, all the emails and so forth, do you feel that there must be some outstanding documents, something that you have not been given to help elucidate how this all came to be, how this, how the decisions were made?
Yes, well, for one, just common sense. I mean, I don't think that anyone is cleaning their email box and selecting which emails they're going to get rid of and which ones they're going to save. They're just, I mean, so I don't see why Lisa Wayne would have provided the few emails she did, and where are all those other ones, you know? That doesn't make sense to me. And also the fact that Anna Alvarez claimed this big process for deciding what to put on those signs, in this paper that she wrote, and yet there's no substance to that. They had these, it was vetted through a review process inclusive of staff participation from operations, capital, and public affairs, as well as a review of existing regulatory guiding documents. I mean, she's claiming that there is a substantial process, and yet there's no paper trail of that process whatsoever.
Okay, that's what I was getting at. So some decisions were made, and you'd like to know who made them and why they made them. And so I was asking, do you feel that has the Rec and Park provided you enough information for you to understand that process?
No, I never saw a document in what was produced that showed even like an email to Priority Graphics telling them what was going to go on the sign. All I saw were things about stickers that were going to go on the signs after the signs had already been put in place. Those were the bulk of the emails that went to Priority Graphics, but nothing earlier that sort of would lead you on the trail back to who made this decision.
So there was no information about what went on the signs and who made that decision.
Right.
Right.
There was only one thing. There was an image of a sign that was an earlier natural areas sign that Christopher Campbell from the NAP sent to Denny Kern and Lisa Wayne, and it was a draft version of the sign from 2009 that says bikes permitted on paved paths. But I suspect, dating back to 2009, that was way before the project to put these new signs up was even envisioned. So it wasn't really relevant to the current signs. That's the only thing that was provided.
Okay. Member Wolf?
So, Mr. Borden, did you receive any communication from Rec and Park to the subcontractor detailing what they were ordering on the signs?
No, I did get, there were two contractors. There was Nicole's work that installed the signs, and there was Priority Architectural Graphics that actually printed the signs. So I was more interested in the stuff that went to Priority. I did get a list of where the signs were going to be installed. I got a list of how many signs were going into each park area. I got some various emails about stickers that were going to sticker over, some language about bikes and some things about dog walking in particular parks. But I didn't get any of the early stuff that would have shed light to allow me to work backwards to who made the decision to put that language on the signs.
So I'm not sure this is going to actually get us to who made the decision, but it does seem like Priority Architecture, can you say the name of the company again?
Priority Architectural Graphics.
It seems like Priority Architectural Graphics had to receive some sort of order from the city with the content on the signs. They didn't just call up the company and say, put this on a sign, because I don't see that happening. So those documents about, this is what we want from you guys, you do not have in your possession. Is that correct?
I think so.
And then a question for the representative from Rec and Park. How did the communication to order those signs come about, and why is that documentation not part of what Mr. Borden has received?
The first part of your question, I can't answer. I'd have to go back and look. I can't answer the second part either. I don't know.
Do you know when that thereabouts happened? This order for the signs. I don't know when these signs were installed.
Judging again, my role in this is just collecting the documents, but I can say probably. Actually, I can't really say. I know there are some of the documents are between the contractor and some of our employees going back, I want to say, probably late 2014. That's the best guess.
So we're not going all the way back to 2009 when these signs were ordered. They were ordered in the last couple of years.
Correct.
And so Do you know if what Borden has asserted that those documents with the communication?
Sorry, what?
Do you know whether what you've provided to Mr. Borden does not include communication between your department and the architectural design firm that created the signs?
It does include. There are communications.
Between your department and the sign design company? Because it seems like Mr. Borden just asserted that there isn't.
There are.
Okay. I don't know how to get to the bottom of that then now.
Member Rummold.
Well, so in listening to everything, it sounds like Mr. Borden is saying, I don't have anything responsive to item number 2. They're saying we gave you things that are responsive to item number 2, and without having them provide us or Mr. Borden with a list of the documents that they think are responsive to item number 2, I don't really know how we can weigh whether or not they've responded fully to the second item. And honestly, I mean, in reading the second request, I mean, I honestly think that the contract might actually be outside of that, and I think a fair reading of it wouldn't include the contract, so I don't fault you for not providing that, but I think if it's true what Mr. Borden says, that there's nothing about the decision-making process that was involved in creating this signs, that's also a problem, but we're at this back and forth where you say there is information about the decision-making process in there, and he says there isn't, so I don't know that we're going to get to the bottom of it just asking more questions.
I have one specific question that we haven't really touched on, and this was one of the things Mr. Borden asked for in number 2 was what public input went into the decision-making process? And I would also add, he doesn't include this here, but maybe it was in another item, what sort of policies were being followed or what sort of regulations were being followed? Did the public if there was no public input, was there ever like a department meeting where this was on the agenda and there were some minutes and we would know who was there, or was this ever an item for the Rec and Park Commission at a public hearing?
It was not.
That's interesting. Member Pilpel.
So 2 more things. And again, please don't be surprised if we discuss later under the administrator's report sending another letter back on our earlier issue. Can you give an example, since it sounds like you put the documents together? We haven't looked at the FTP site. Can you give an example of a document that was provided in response to item 2 that you believe responsive to suggest how the decision was made? You said that you believe there are records responsive. Can you give me an example?
There was an email from one of our designers to another designer who was designing the sign. At least one, possibly more.
Like a department staff person? I mean, who's a designer?
Correct. One of the department designers.
Okay. But that's more on what you suggested earlier, the mechanics for the implementation. Is there anything that goes to the question of how the decision was made to put the sign? Not like, the content, but like that we're putting a sign there to begin with that'll say something.
There was not, no.
No. So.
And why not?
Yes, that's a good question.
I can't answer why not.
So if the department is putting up a sign like, I don't know, across the street in Civic Center Park that says no kids or no adults in the play area or stay off the grass or whatever, presumably someone's designing that. Who makes choices about putting up signage in that park or in the other parks in this city?
All I can tell you is there's no document responsive to that question.
That's not the question.
There is no document.
Please answer the question directly. He's not asking for documents.
I am answering it. Actually, I would argue.
He's asking you who makes that decision, and you're saying there's no documents.
Phil Ginsburg.
No. Phil Ginsburg is the general manager. He runs the department. He's ultimately responsible for the department, but he doesn't make every single decision in the department. That's not possible. That doesn't happen. Other people are empowered within the department to do various things, and you can't seriously tell us that Phil Ginsburg makes every single decision. I mean, Phil Ginsburg doesn't get out there at 4 in the morning and cut the grass at every park. You know that. I know that. We all know that.
Okay.
So the question was, who makes those choices? And you're saying there are no responsive documents. That may be true. In the absence of responsive documents, who makes those choices? Who is responsible for placing signage in the parks?
I've answered your question several times.
You
Answered
haven't.
Your question. You don't have to accept it. You can disagree with it.
You haven't answered my question.
And I'll answer it one more time by saying Phil Ginsburg.
And that's not true. So you're now giving false testimony to this task force.
Member Pilpel. Okay, I just, this is me talking to the task force, thinking out loud. So this is the second time we've had a complaint come before us where Rec and Park has done something without any sort of process or accountability or making decisions on the public's use of public land without any apparent input from the public, without any reference to any policy or regulation. And from the public's point of view, from my reading of all this, these decisions are made without any paper trail and without any public comment. And these are decisions that affect how everyday people use our parks. There may, in fact, be nothing on paper, but there should be. And I'm wondering what the Rec and Parks Commission is the policy-making body for the Rec and Park Department. It seems like they might have heard something along these lines at some point, or they should be holding public hearings about. We all know that these are important matters to the public. These are, hot button topics, and we all get exercised about them. We dog owners, we bicyclists, we joggers, all of us. So, okay, I'm not going to say anything more. At this time, is there anybody else have any
I have one more question for the Rexham Park representative. Could you state your name and title?
Eric Pulowski, Planning and Performance Analyst.
Analyst. Who do you report to, Eric?
My immediate supervisor is Taylor Emerson. She reports to Director of Administration and Finance, Catherine Petruccioni.
Thank you. Whatever we do find, I'm tempted to throw in a 21E violation.
Yeah, me too. Yeah. All right, at this time, we would like to hear rebuttals.
Yes.
I'm sorry, Member Wolf.
This issue could come up after the rebuttals instead, but it seems like we have this difference of interpretation over the actual documents that have been provided. The documents that have been provided aren't part of our record that we have here, and I'm trying to figure out how we're supposed to assess these issues without actually reviewing the documents provided, and I'm looking for insight from my fellow task force members on that.
Member Rummold.
So there were some links to FTPs that they provided of the documents.
What page is that?
Let's see.
While we're looking that up, I do have one more question for Mr. Eric, if you could approach, please. Sorry, through the chair.
Vice Chair Hyland.
Did you run those searches as Mr. Borden suggested with his search strings?
Yeah, we did. We followed his instructions. Like I said, it wasn't as simple as just search these terms. It was there were some contingencies built in.
Okay, thank you.
All right, that's at the bottom of page 292. Okay, any other questions from the task force? Okay, at this time, Mr. Pulowski, you have 3 minutes for a rebuttal.
I have no further comments. Thank you.
All right. Mr. Borden, you have 3 minutes.
Thank you. Just in terms of what documents were provided, I did provide quite an extensive list of that you do have called chronological list of findings. And I went through every one of those things to the best of my ability and made notes and organized it in terms of time and tried to see how they all tied together. I didn't find anything that pointed to directly to who made the decision to put the no bikes on the signs. But that's all there. And I do want to point out that another sunshine request was subsequently filed by Alex Aldrich, and one of his requests was, please share the documents that show who and when the decision was made to put no bikes on the signs erected in February 2015. So basically asking my question 2 all over again. And the response from the department was, the department has no documents responsive to this request. And it's basically the same thing that I received, nothing. And it's just, I can't believe it. That's all. And
Yeah.
that's all I have to say. Thank you.
Thank you. Okay, the matters with the task force. Members, is there a motion? Member Pilpel?
I'm not sure that I'm in a good position right now to make a motion because I'm annoyed. I want to be very clear that I will support a motion that if someone else will make it. But I also want to make very clear on the record that I am extremely frustrated with Rec Park, not about their dealings with off-road bikers and trail use. That's entirely up to them. What I'm frustrated about is their inability to provide documentation about decisions made and their failure or disregard for a public process about restrictions on trail use and these kinds of controversies. This is exactly the kind of thing that should be discussed publicly at community meetings, at the commission meeting, and in public venues to debate controversial issues and not to just put up signs and say, oh, well, signs went up, but we have no documentation as to how the signs got up. Actually, we paid for the signs, and somebody figured out what to put on the signs, but we have no idea who decided, or we can't figure out or document who put up signs less than 2 years ago that say some things that people are really concerned about. That just seems outrageous to me. I did go to the last Rec Park Commission meeting on a different item where, I made a comment and there was a question asked, and yet they approved the thing without any real debate or discussion. So, thinking about it more, I'm not sure that the commission is rigorously vetting things from staff. But be that as it may, at a minimum, there ought to be public discussion and perhaps commission action on this. And that was what our last letter was intended to do, and et cetera. So I'm happy to support somebody's motion to find a violation here.
Member Wolf, do you have a motion for us?
I am also in a similar position around the motion. The FTP is no longer active, so that's not possible to analyze. It does seem in reviewing the records that, was it Pavlovsky? Was that Eric's last name? Mr. Eric Pavlovsky's assertion that Phil Ginsburg makes those decisions, as Member Pilpel asked. There is records in the email chain to indicate that. And there does seem to be like a violation of the sort of due process in making these policy decisions that the Rec and Parks have superseded. But I don't really think that's a sunshine issue. So I'm a little confused what our best course of action here is. And I'm not seeing any explicitly obvious sunshine violations, but I am seeing a lot of concerns and potential violations, but not the evidence to support them. So I'm confused what is the best way to proceed.
Other members?
Through the chair.
Vice Chair Hyland.
I just thought I'd throw this to DCA 3 and see if you had any input. And I know what he's going to say. Do you have a specific question? My question might be, aside from 21E, is there anything else that jumps out as a violation?
Through the chair to Member Hyland, I don't have any suggestions. It's not really the role of the city attorney to suggest violations to the task force.
Thank you. So to the members of the task force, I think, we're looking at 6721, were the records provided or not? And we've come across this before, can we find violations for records that don't necessarily exist? And that's the fine line we're treading here. My instinct tells me one thing, but I think at least a 21E, I'd like someone with a little more authority from Wrexham Park here in front of us to address this particular case and other questions that have come up about Wrexham Park. So that's, if nothing else, can we not just find a violation of 21E?
What did we find in the earlier case? What were the violations we found? Was there anything, 67.29? Does that apply? -7, does that apply? Not? In a case where we think that, I know we've found that before, where departments aren't keeping records that we think they ought to be keeping.
Yeah.
So
It was 15087, if we can look that up. Hold on, I can't find that. That's why we have a chart. We found the recommendation that a violation of Section 21B occurred. Order of jurisdiction, or jurisdiction? Should be order of determination. There should be an order on 15087 that's on our website. If someone can go there. Fif- 15087 on our website. Can you go to our website?
what the OD was on that case.
So I'm just, through the chair,
Yes, Member Rummold?
I am looking at page 316 of the packet, and in Mr. I'm sorry, this is kind of a little off topic. Well, I don't think it's off topic.
No,
but
no.
It seems like
We need
this
all the
is
help we can get.
This is so the Alvarez response number 3. These are the signs that were reviewed and ordered along with the entire new park signs. If you recalled, you and I discussed the language on 2 occasions since you'd asked me to have Lisa review to align with the new park signs, not new policies. However, the sign, I mean, that seems to be a little bit of, that seems to be an email that is responsive to the second part of the request and gets to people who are making the decision within parks. I mean, maybe I've got the signs wrong that they're talking about.
Which page, which item?
316.
316, the top.
Okay.
Yeah, that's kind of ambiguous as to what, are they just referring to the particular language that we're going to use rather than a decision to put signs in all these areas, you know, the bigger issue of what's going to be off limits. And I mean, I think that's what everybody wants to know. Why can't we ride our bikes here? Who decided that?
Well, it looks like these people.
Well, the way I'm
People
reading,
involved in this communication are the ones who did.
the way I'm reading that through the chair is to review to align with the new park signs, not new policies. However, the signs may have corrected misinformed users. So the way I read that is that the old signs did not lay out the restrictions. The new signs do lay out the restrictions, and those restrictions have been in place all along. It still begs the question, who put in those restrictions in the first place? We're still getting back to that. That's kind of how I read that, and there's no... But you're right, there is some discussion at that policy level, operational level, and it would be nice to have these people in front of us answering our questions rather than, no disrespect, an analyst.
Member Wolf, did you find anything for us?
So the corollary to that I see, though, is if you go down to page 317 and look at the 3.2 email summary, we have that that Ginsburg, he would like us to continue to allow bikes at interior Greenbelt. So I need to get a sticker over no bikes as soon as possible on that sign. So there's this decision being made on the fly of where bikes should be allowed even after the signs were printed, which is directed to Ginsburg making that decision. So that's sort of the second part that I read after looking at what Member Rummel cited earlier. In terms of a potential violation, I think we should also look at, 67-22 around oral information, which I seem to have no longer have in front of me right now. But in the extent that basically this is a question that the complainant is trying to get an answer to, whether or not there's documents supporting it, Mr. Pavlovsky's responses in this hearing itself have indicated that if it's not pertaining to a document, he's not answering the question even to Mr. Pilpel's original inquiries, and that to me starts to raise a violation of 6722.
Through
Very
the chair.
interesting. Yeah.
I think
Vice Chair Hyland.
maybe we should cobble together a motion and get some public comment on it, because
Yeah.
we might have some more input from members of the public, I'm sensing.
Yeah, I see somebody who might have something.
We could take that comment now, but maybe we
Yeah,
should
let's draft something. Okay, so Vice Chair Hyland or Member Wolf
I had
or somebody.
I had a clarifying question to Mr. Pawlowski that might help me a little bit.
Okay.
Mr. Pawlowski? On the top of page 316, one of the emails that was referenced, the summary here, I don't know who Ken Kelly is. I can just ask you about names. That would help. Can you tell me who Ken Kelly is?
I cannot.
Okay. Robert Watkins, is he now a Park Service Area Manager?
He was at the time, but Robert actually was recently injured. I'm not sure if he's back at work.
I hope he's better.
But he's...
In any event, I hope he's better. At the time, he was the Park Service Area Manager for the area that included McLaren.
He was, yes. And he always been. When he was injured, his position was taken over on an interim basis.
In any event, does he roll up to Anna Alvarez?
Yes.
Okay. Do they have periodic meetings of Anna and her staff to discuss specific parks in the various Park Service areas?
Yes.
Are there notes kept of those meetings?
I don't know.
Okay. So among other things, I would ask you to find out if there are notes of those meetings, because perhaps notes from those meetings related to that particular Park Service area might reveal discussions between him or his successor and Anna and others about restrictions in McLaren Park. And I don't know if that was something that you searched for, but maybe there's some there, if there are, in fact, notes of these periodic meetings. Thanks.
Right, those were specifically mentioned, and it looks like there was just a search for emails, as far as I can tell. Do I hear a motion? Somebody?
Yeah, I'm sorry.
Vice Chair Hyland? Member Pilpel?
I mean, I think if you think there's a thing here, I think it's a 21B thing and a 21E thing.
Yeah, maybe a 22 thing.
I'm less convinced that there's a 22 thing because I think that's only the designated oral public information person, who's probably Sarah, and I don't know that Mr. Borden was asking for oral public information. I think he specifically asked for responsive records, got some, didn't get all, and our concern is that. One could argue for 29-7, but I'm also not feeling that. I'm feeling 21B and 21E.
I would second that motion.
Okay, we have a motion. Mr. Young, would you read that for clarification before we take public comment?
The motion is to find a violation of 67.21B and 67.21E of the Sunshine Ordinance.
Okay, is there any public comment on this?
Before you start, I remember, Pelpo, you made that motion, and I want to confirm that Vice Chair Hyland made the second. Thank you.
See where it goes.
Good evening. My name is Bruce Wolf, and tonight on this issue, I'm going to be speaking as president of Dog Pack of San Francisco and the entire dog community of San Francisco. This particular signage around, new signage that went up around McLaren Park had gone up kind of rudimentary. So this is a direct experience on how actually I was able to find out who to talk to and how to get it fixed administratively. Signs went up that notated that off-leash dog access would be in certain areas and not others. So for one example, there was some new signage that went up around the amphitheater, the Jerry Garcia Amphitheater. And there was basically the way the law is written, that particular location is not included for restriction of off-leash. But there is an understood understanding that during any events, that dogs can be allowed, but they must be leashed. Okay, so signs went up saying off-leash area, basically no dogs allowed. So we came back and we said this is incorrect. And when the natural areas program signs went up, it equally put up very general on leash and no dogs allowed in certain areas. It's a very large off-leash area in McLaren Park. It's very well known, gets used a lot. So we all knew this was incorrect. A lot of people got together. We got in contact with Director of Operations, Dennis Kearns. He was the one that put the ball into motion. There were some new people that deal with certain aspects of signage. So there's one person that deals specifically with dog play areas. There's another person that deals with, maybe the disc golf and so on and so on, or maybe a combination. But in this particular thing, it was the natural areas signs. Those signs were taken, I think they were taken down, redone, or repositioned into proper areas. So frankly, I'm a little concerned about the testimony from Rec and Park here. I think what you have is the wrong representative, and I think I have to urge, complainants that when they make complaints to actually make a complaint against a person and not against the department, unless the department is not helping you find out who the correct person is. Because it's a lot easier to find violations of people than it is of departments. How do you then put an order of, who do you put an order of determination on then? So hopefully that was helpful for you.
Can I ask you?
Thank you. Member Pilpel?
So to former member Wolf and present person Wolf, and happy to see you. I appreciate your testimony very much. Based on your experience, not necessarily on the task force, but as a person that was, it sounds like, involved in this process, would it surprise you to hear that they don't have clear documentation for those discussions and decisions?
Oh, it would be very surprising. I mean, when we approached them on this, they really didn't have. It's really what they do have documents. The document is the law. The law identifies, the Parks Code identifies where restrictions are, where restrictions are not. Where it's up to the department to actually create a restriction, there's got to be a public process for that through the commission, more or less. And especially when it comes to creating new restrictive areas. Now, under the Natural Areas Program, it's very convoluted, and, the dog community is very concerned about it because they're going to be removing a lot of the registered dog play areas to reclaiming it. So,
fair enough. Suffice to say, given the controversy on all sides, wouldn't you suspect that they would maintain documentation of discussions or agreements or decisions made in this area? And not doing so and not having it available would seem
absolutely.
unusual.
Let's go back to the George Wooding case.
Thank you.
And many of you may not know that, but I'm sure the more senior members can reiterate that for you.
Got it. Thank you.
Thanks.
And
did you?
And through the chair, another question. Who was was it David Kearns?
Dennis Kearns. They call him Denny. Denny Kearns.
Denny Kearns.
He's the director of operations.
Thank you. To that note, can we include his name in any deliberations we have, or separately in a memo just for due process, or rather letter from our task force? What I'd like to do is have the motion also address him specifically.
And request that he come to.
Yes, appear before us at the continuance.
Exactly.
So that was what I was going to add there.
Is there additional public comment? Oh, sir, you were a party to the matter. So.
Unfortunately, we can't let you talk at this point.
Okay, the matter's with the task force.
So if the maker of the motion would be willing to add addressing this to...
I believe that would be part of the chair's...
okay.
Yeah.
Do it that way.
Yeah, I think we will carefully write this and maybe wrap some of these comments in the response to the other letter, because I think that they are somewhat linked. I would suggest that at a minimum, Mr. Pawlowski, what did we say? I mean, we can put a lot of people on Rec Park as CCs. I think you said, I'm missing it now. Your immediate supervisor, remind me again.
My immediate supervisor is Taylor Emerson.
Taylor, right. I apologize. Thanks. We can certainly copy it to Taylor. Katie, I think Sarah Ballard is not on the list here, but is involved. Certainly Phil, Denny, Anna Alvarez.
Yeah.
I mean, after spending all this time, both tonight and at the prior hearing, I don't feel like, even with all the people that I know and the stuff I understand there, I don't have a sense of how this thing works within the 1,000 people that are Rec Park, and that's disturbing.
Yeah.
And so I definitely think if we go this path, we should send this to a committee, have follow-up, and try to get somewhere.
On that motion, to find violation of 67.21B and 67.21E, Member Rummold. Rummold, aye. Member Eldon.
Aye.
Eldon, aye. Member Wolf.
Aye.
Wolf, aye. Copra, absent. Member Pilpil.
Aye.
Pilpil, aye. Member Haynes.
Aye.
Haynes, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Washburn.
Aye.
Washburn, aye. May I have the chair's action on this matter?
This should go to compliance and amendments, and should be sent to all those folks that we discussed.
Member Pilpil will provide the official
Right.
CC list to me.
And, we need to cross-reference the earlier case. These are similar issues. We need to request that someone other than Mr. Pawlowski appear before us, someone who is knowledgeable about how policies are interpreted and implemented and how decisions are made about all these things happening in the parks.
I mean, I don't need to see Phil here, but I think we probably need Sarah and either Denny or Anna. That's where I think it's at this point.
Yeah.
And whatever else we need to do, we'll take it from there.
I believe that it will be referred to the Compliance and Amendments Committee. We're going to be providing additional information. Is there anything that you want them to provide at this meeting?
I don't know how thoroughly they researched everything that Mr. Borden listed in his number 2. He asked for emails. It seems like they provided a lot of those. Meeting notes, memos, minutes, anything that would shed some light on how decisions were made about what these signs should say and where they ought to be placed.
I also suggested earlier any notes from the Park Service area meetings from that area.
How do you spell that? Park Services?
Park Service area, and I don't know what the number is. Do we know from McLaren? We'll figure it out in any event for the Park Service area, including McLaren Park.
Thank you.
Okay.
Would you like to move on to the next item or go back to the complaint procedures?
Let's see, what do we have left here? We have some minutes to approve. We
And
could
the
do
administrator's report.
We could take a break and then come back and work some more on the complaint procedure. What are members' preferences here?
Is it worth it to, do we have to finish the complaint procedure today? Do we have to finish complaint procedure today? Can we maybe take some time to digest it and revisit it next month?
We could do that, yeah, and go home a little bit early.
Yeah, is there any deadline or anything?
No, there's no deadline
Josh
whatsoever.
has something to add?
Member Wolf?
I know this is not what people want to hear, but the likelihood of us getting out so early this month and addressing it now versus next month, who knows what's on the agenda, and the likelihood is that we'll be doing this at 9 o'clock, being like, can we push it off for a month? I see there being an advantage of at least dedicating another half hour on it, if nothing else, to make a little more progress than to, utilize this unexpected early absence, which I also would like to take advantage of, but that's just where I'm at.
We've lost the members of the public who are very invested in this.
Through the chair, I was just going to say, maybe we can push through the non-contentious, the technical issues, question of typos and whatnot, and the things that maybe should be discussed with the members of the public present, we can then address at the next meeting. That's what I was going to say. If we can move through things which are not, too hard to deal with, that we can, take care of now, at least that's worth an extra half an hour, 45 minutes, I think.
Right. I've gone through for typos, and so as former chair Nee, I was planning to give those to Victor, so we'll do that.
And, through the chair, we could tackle more substantive issues, too. We announced what we're going to do. I think within our rights to do that, if we want to do that.
Right. He chose to leave. Okay, why don't we go through the rest of the agenda, see how we feel, see if anything, sit on it for a few minutes.
So we'd like to go through the remainder of the agenda. Item number 8, approval of minutes of the Sunshine Ordinance Task Force, November 4, 2015, and December 2, 2015 meeting.
I have edits. I'm almost done with December 2nd. I'm definitely done with November 4th, so I will move approval of the minutes with edits.
Do I hear a second? Is there any public comment? Okay, I've gone through the minutes from the December 2nd, November 4th. I have very minor, teensy little edits. So without objection.
Is there any public comment?
I already asked for
Oh,
it.
sorry, my apologies.
Okay, without objection?
The motion is passed without objection with Member Highland and Member Copra being absent. Next on the agenda is item number 9, approval of minutes from the Sunshine Ordinance Task Force Complaint Committee, October 27, 2015, and November 17, 2015 meetings.
Again, I have some edits, so I will move to approve with edits, but I did want to note, because I thought it was fun, that I was at one of the meetings but not the other, and yet the November 17th minutes suggest that I made a motion and voted on a couple of things. And I thought that was kind of fun. It's like, I wasn't even there, but anyway.
I missed that.
Nevertheless.
Oh, yeah, okay, right, all right.
My presence is felt even, never mind.
Is there a second?
Member Hinsey?
Oh,
you want a
member,
second?
did you second it? Okay, all right. Any public comment? I have some edits too, which I'll pass on. Seeing no public comment?
And I'm sorry, I also changed the order of the vote so that it's consistent with our normal practice, the second member, the third member, and then the chair, which is normally how we call.
Okay.
Vote. Anyway, fine.
All right, so without objection?
That motion passes without objection with Member Copra and Member Highland being absent. Actually, Member Highland was in the room. The vote passes without objection with Member Copra being absent. Next on the agenda is item number 10, Administrator's Report, Complaints, and Communications. Going through the Administrator's Report, second item, January 11th is the next meeting of the Education Outreach and Training Committee. I currently have the members of Chair Highland, Member Pilpil, and Member Wolf. I was wondering if there's any issues with that membership at this time. It seems that membership is acceptable. We have 3 new complaints being heard on that day, in addition to a procedural matter that the committee is working on.
I still have to do some more work.
That's this coming Monday. The complaint committee was scheduled for January 26th, but I do not foresee a need for them to meet at this time. The next meeting of the Sunshine Ordinance Task Force is February 3rd, and the next Compliance and Amendments Committee meeting is on February the 15th.
On that, Chair Washburn, not necessarily tonight, but certainly by the next meeting, you should consider appointing a new chair to that committee since Member Hepner has left us.
Right. So we're down to
Yourself.
to me. Okay.
Committee
I'd rather
of
not be the chair. So I need 2 more people to join me and
Compliance and
somebody to
Amendments
chair
Committee.
it. So I'm looking at Member Haynes and Member Eldon.
They are, I believe, on the second Tuesday of the month.
Right. At 4 o'clock.
Third Tuesday.
Third, yeah, it is the third
The
Tuesday.
third Tuesday of the month. My apologies.
February 15th. Valentine's +1.
What else am I signed up for right now?
You're not officially assigned to a committee at this time.
Okay.
Currently, you've been filling in for other vacancies.
Okay.
Yeah, this is a good one.
Okay, yeah. I'd rather just pick something where there's a hole and stick to it every month, so.
That'd be it.
This has a great big hole in it, so.
Okay. All right. Guess it's me.
So I've got two good men here, right?
Our meeting is on Monday.
We need to get you our committee preferences anyway, right?
It's February 16th, not the 15th.
Yeah, I asked for committee preferences, so I don't know, about 6 months ago. We've been really winging it. Are you happy where you are? Okay, all right.
Yes. Rule/complaint.
So you still need someone to chair.
Yeah, someone to chair.
Okay, yeah. Count me in.
Yay, okay.
Member
Stepped up.
Eldon is assigned as the chair of the Compliance and Amendments Committee.
The chair.
Wait, I'm the chair?
Yes.
Mazel tov.
You just landed in the musical chair.
I thought you said
This is the part where I was.
You didn't stand back fast
You
enough.
you just volunteered yourself.
I'm not sure I'm familiar enough with
You're
the
fine.
intricacies.
I will
of
assist.
this.
and I'll be there.
Okay.
Yeah.
So you're going to be, you're a member?
Yeah, I'm a member. I used to chair it before me. Former
Nee.
chair Nee chaired it.
Okay.
It's
Long history of wonderful people. So.
All right. Well,
before, right after me, former member Hepner. Yeah, quite a
I'll
lineage.
do my best.
Doing it right now. You're sitting in a chair. That's
And for the third member?
So, Member Haynes, you'll be able to
I believe that we can.
well, let us know as soon as you can. Okay.
Okay.
Oh, good. Okay, we're on.
And I believe you're assigning Member Haynes as a regular member. Is that correct?
Yeah.
Yeah. Thank you. I have listed 4 communications, which is in your packet today. I believe there is one communication here that Member Pilpil would like to discuss from Recreation and Park.
Oh, yeah.
Item number 4, complaints submitted this month. I have them listed. There were, I believe, 6 new complaints submitted within the last month. Going on to item number 6, we have a total of approximately 29 complaints pending before the Sunshine Ordinance Task Force. 15 of those complaints will be heard by the task force. They were previously heard by the CAC on 12/15, and they've been referred to the SOTF to be heard on February the 3rd. And so approximately half of our items have already been heard, and they're being referred to the task force for review and approval, and possible approval.
Couple of questions on that. Remind me, of those 15, how many were recommended violations? Was it like 4?
2.
2? That's it? Okay. So we'll talk about those next month, but we should set it, I mean, that'll take some time to
These
go
are
through, but then we'll.
Antrobose
Yes.
matters. Okay.
And I should also note that I have a complaint pending, and I finally heard back from Environment, and they want to meet with me, which is what I wanted. So we'll see if that can go away and not have a hearing.
Next on my list is item number 8. I did have a discussion with Member Rummold, and I believe that the memo regarding police public records policies has already been addressed. So there are only 4 pending items or pending issues. The annual report will be scheduled at our next meeting. And that completes my report.
So Chair Washburn?
Yes, Member Pilpel.
So a couple of things. On item 8, the pending issues, I still have a thing there. And Member Wolf, you were still pursuing the body-worn cameras and drones?
The drone thing seems to be almost exclusively being dealt with by the FAA, which is a federal issue, so I'm not sure where we can go with that. And I've done some preliminary research on the body cam, but I'm not entirely sure what our actual role in that really is supposed to look like.
So on those two things, the city is still apparently discussing a drone policy. It hasn't seen the light of day in a few months, but apparently it's being discussed behind closed doors. Obviously, it would have to be consistent with the FAA, but to whatever extent the city is considering a drone policy, I think we should take a look at it and possibly weigh in. So I'm happy to route you to the right people. I thought you were...
I mean, after my amount of research, I'm happy to continue with direction to put something together with the body-worn cameras. The drone issue seems to be... There's reasons that I don't think it makes sense to continue to pursue it, but if someone else on the task force would like to, I'm more than happy to share my research and help them along.
Okay. And I still hear about other potential surveillance-type ideas with technology in the city that concern me. and perhaps should concern us. On the police body-worn cameras, the commission did adopt a proposed policy, and now it's going out for meet and confer with the union. I think we could invite someone from the police department to present it to us and discuss in particular how they're proposing to address retention of video records, disclosure of video records, and what complaints or appeals might come to us from that, because I just foresee issues with that, and I want us to be sort of ahead of that before we start getting a bunch of complaints related to body-worn camera videos. So that's my thought, is to invite somebody from them, either for February or March meeting.
Well,
We could
looks
do
like-
it at a committee, but I think it's pretty important stuff.
February is going to be pretty full, so
February is.
Shall we
Yeah.
try for March?
sure, that would be an interesting.
That was a March meeting to discuss the body camera issue. Am I correct?
Yeah. So I will check with some folks at the police. If we need to send a letter inviting them, we can prepare that for you to send.
Okay.
All of that? Okay.
Sounds good.
Okay, so that was my stuff on item 8. Turning to the Rec Park letter that I suggested earlier, that's in our packet at page 382. I didn't have a chance to ask him, but somehow I suspect that this letter might have been written by our friend Mr. Pawlowski. It bugs me that their response talks more about the bicycle use in parks and very little, if at all, about how their policies are adopted and documented. The best that we got is the last sentence that says that they agree with the task force that more clarity with respect to off-road cycling policy is warranted. Yeah. So, I did not bring a draft of a response tonight, but in my head I have kind of a draft, and maybe I will just bring it to our next meeting. I think we should continue what could be a productive dialogue and isn't yet on our view that their policy should be documented and, perhaps subject to public hearings and that sort of thing. What an idea.
No, I agree.
I'm just not sure. Maybe we're not talking to the right person, or maybe they don't get it as an organization or something, but am I the only one that's feeling this way?
No,
Okay,
I think
all right.
this is one of those situations where it looks like we've uncovered a real systemic problem. And that's one of the rewards of working on this commission. Member Wolf?
I agree with everything Member Popo said, except I'm not entirely sure that responding in the form of a letter is the best way to advance this item forward. I mean, in essence, we have a, thank you, fuck you email. And I don't think that continuing that conversation is actually going to get us anywhere. I think that probably, having them in through one of the committees or trying to address this more proactively with the next public, the next sunshine violation may be the easiest way to address this, as opposed to this letter, which, unless we're also publishing it to outside media, is just going to end up with this back channel, polite fight that's a waste of everyone's time.
I have no problem with that. I mean, I can try drafting something, and in the meantime, I have no problem alerting the media. I've been pretty okay at getting stuff in various places. And I can certainly try to go to the next Rec Park Commission meeting if the task force is okay with it and represent that we are concerned and we would like the commission to be aware of our concerns. I'm not sure that they got the letter that we sent, and we can try. I mean, hope springs eternal. I mean, ultimately, we might have to do a letter to the mayor and say that his department head and commission are just, whatever.
Do we want to? I'm feeling as Member Wolf. This letter is pretty pathetic and almost doesn't warrant us spending a whole lot of time trying to respond to it. We have another case, same old thing, and it'll be heard at the February compliance and amendments with our new reconstituted committee, and maybe that'll be the time we'll be armed with 2 instances of this problem.
I may join you for that meeting.
And depending on what happens there, I think it would be a great project for us to go to Rec and Park Commission, maybe get on the agenda, or in general public comment, and say, hey guys, the way you're doing this is not serving the public.
If I'm able to go in January, I guess I would need the approval of the task force. Does the task force have a problem with my representing our concerns to the commission? Yes. Diplomatically. I might not use Member Wolf's comment about the letter.
So members, how do you feel about Member Pilpel going? Member Wolf?
If that's when it starts to make sense to like approve, like I have concerns about any member of the task force trying to speak on behalf of the task force when there are these sort of moving pieces and their response instantly shifts the situation and the whole task force isn't aware of that. If we had a letter in hand for Member Pilpel to read at this point in time, I would wholeheartedly support that. The sort of speaking off the cuff for any member makes me a little bit concerned when representing the task force. It's nothing personal about the member at all.
Fair enough, and I don't like getting up in the morning to go to meetings anyway. But if I'm able to, and if I can speak from our previous letter, which I think was pretty clear, I guess that's my offer.
Through the chair.
Vice Chair Hyland?
I think we should be a little careful in this case, only because we have some history here with this kind of thing. I think either the chair or the vice chair should be the one to read any letters from the body. That would just be my.
And we also have this other case pending where we would like to get some real information from them. So maybe now's not the time to make those waves. Who knows? They may appear and have all their policies and everything right there for us to look at.
However, if Member Pilpel wants to vent by donating to the Dog Coalition, I would wholeheartedly support that.
I'm happy to wait. Maybe you're absolutely right, and this is why we bring it up. The February compliance meeting is on Tuesday, the 16th. The full commission meeting for Rec Park is on Thursday, the 18th. So maybe, depending on how things go at the committee meeting, if we find a need at that point to communicate more strongly to the commission, we'd have that option. That seems fair.
Although we may want to bring it back to the full task force in March to discuss that.
Fair enough. But we might want to alert them. We'll see where it goes.
Okay.
Maybe we'll just play this out. That's fair.
All right. Are there anything else with the administrator's report?
No, I completed my report.
Okay. Is there any public comment on the administrator's report? Seeing none, we are. Oh, certainly. Yeah.
You've been holding this back for 30 minutes, haven't you?
In regards to David Pilpel's response to the park department, is that I think both Tom and I's request is not just about bikes, it's just about policies as well. And that's clearly what the Recreation and Park Department is not adhering to. That I would rather this go to the mayor as well as, I would say, a media outlet of some kind to let more of the public know than just going to a commission meeting, because they are aware of the situation and they haven't done anything about it. Thank you.
The commission is aware of what's going on.
Yes, because they received several letters from different people in regards to people asking about the signs. People have gone to the meeting. People have given presentations. They haven't taken it up as an agenda item. They haven't listened to the public at all, which is, I think, the reason why this is a much bigger issue than the Park Commission or Phil Ginsburg, that I would rather it go to the mayor and also a media outlet instead. Thank you.
Thank you. Okay, we're at the last item on the agenda, adjournment. Do we want to take a break and go back to, oh wait, announcements, I'm sorry. Announcements.
Let's do announcements first.
Let's do number, could you call item number 11, please?
Item number 11, announcements, comments, questions, and future agenda items.
I only have 3.
Go ahead, Member Philpott.
So I spoke the other day to Leanne Pelham. She's the new director of the Ethics Commission, started on Monday. I suggested she might want to drop by either today's meeting or a future meeting to introduce herself. I think it's important that we have a good... She was here? Show it?
I didn't.
Okay, all right.
Oh,
Okay.
I didn't at all. Oh. Okay, yeah, I did see her. I didn't know who she was.
Right.
That must have been blocked.
Yes. In any event, I thought it was good for us to try to have a productive working relationship, and so I hope we will have the opportunity to do that, both formally and in other ways. So that's her and that. I also asked Member Hepner if he wanted to drop by tonight. I didn't see him, but maybe I was blocked again, because I thought it would be help.
He's never coming back.
Well, he's not going that far away.
He's gone.
Okay.
Let it go.
Actually, on that note,
Can't pine away for him.
on that note,
Can't?
Member Chopra, are we still? I keep hearing his name. Is he not a done deal?
I have asked the person who runs the
New California Media?
the New American Media, and she's not responded to our request for, hey, we need somebody new.
Well, I think if we get him off the book, so to speak, at least it's there, and it's we might get some.
I could reach out to her again.
I mean, my understanding is that once a member is appointed, unless they resign, they continue to serve either during their term or as a holdover, unless the board takes a rather extraordinary action and removes them. But even if they were to remove them, they can only appoint someone who's suggested by New American Media. So
Yep.
We're back to them providing somebody with a pulse who will show up.
So the ghost of Chopra continues.
Member Wolf.
I mean, even though they're an appointed member and they're basically going to be a vacancy until they appoint someone new, I think that given that we have, attendance standards and we've been called to task around enforcing those attendance standards by the public, I don't see the harm in, taking the stance that Member Chopra hasn't showed up, has clearly violated the attendance standards at this point beyond a reasonable doubt. That doesn't actually make any sense, but you know what I mean. And to say, now we absolutely need a new nominee because this person has been removed for failure to comply with the standards of the task force.
I would suggest that both the annual report have something about this, and maybe that we send the non-attendance letter to the board, copy to Member Copra, and copy to New America Media. Those seem to be our remedies. Okay, and my last item was on the budget. It is actually budget season around, and although departments have been asked to cut a little bit here and there, we have traditionally not weighed in strongly on what the task force's budget and city attorney support and that sort of thing should be. And if we want to do so, I'm thinking now would be the time, and we should write something up that we could send next month by way of a letter to appropriate people, the Board of Soups, the city attorney, the mayor.
What did we do last year? Didn't we send a letter?
Did.
We did.
I don't know if we actually did. I think we talked about it.
I think we did.
Could
It
you?
was in relation to a complaint, and I don't believe we've proceeded any further on that front.
Oh.
It's certainly something we address every single time in the annual report.
You want me to take a stab at a draft letter?
Sure. Yeah.
And along the same lines, I'm wondering, to Deputy City Attorney Threet, the letter that we sent to the city attorney, have you gotten any word as to whether and how that'll be responded to? I assume that's not your thing, but perhaps they might have talked to you.
Through the chair to Member Pilpel, no, I have not. I did get a copy of the letter. I saw it. It was copied to me, but that's the extent of what I know about it.
Okay. We would love to hear a response from the big guy. I'm done. Thanks.
Anything else? Any more comments, questions, future agenda items? All right. Is there any public comment on PCA 3?
Through the chair to Member Pilpel, the request for a hearing on SFPD body cam policies, I just wanted to make a couple of comments about that.
Great.
The issue of the body cams is actually one that has not been entirely resolved under the law, but is likely to come under the one of the exemptions, at least arguably, for investigatory files. But there is some discretion in whether a department chooses to release those files and how. So it might be useful to do some sort of analysis for that hearing.
I agree, and I agree that some would likely fall under there. The way I read the proposed policy, they might take videos of other interactions, including First Amendment things and other kinds of things. So I don't think everything would be a 6254K issue. But good catch. Okay.
Okay, it is almost 7. Is there interest in spending some more time on the complaint procedures? Just a show of hands who wants to plow through some more of this. Oh, okay. It looks like we want to go home.
So can we go back to it just for the purpose of saying that the choices that we've made so far and direction that we've given should be incorporated, the technical stuff that you had, the RIC stuff should be incorporated, and we should see a new draft and perhaps continue discussing from where we stopped, the beginning of C next time?
Right, yeah. So,
And move to continue with those understandings?
exactly. And then,
Second.
without objection?
I think.
Oh, public comment?
Just to clarify, the motion is to accept the changes, to accept changes agreed upon by the task force to make the clerical corrections as suggested by various parties.
Just the clerical. You said about Rick Nees, and that's not all of them are clerical. Some are
I
substantive.
think we should identify that we're talking about item 2 at this point. Back to item 2.
Right.
Reintroduce
We're
it.
at item 2. So do we have a motion and a second? Is there right, Member Wolf?
So we're talking about approving the changes for the sake of the next draft, not necessarily actually finalizing the approval.
Right.
Okay, that's all I was.
We're going to be working on the rest of it.
Just approving what we've done so far.
Right.
And to continue the matter to the call of the chair.
Right, because we may not have time next time in February.
Is it a full agenda?
February is pretty full,
Yes, it is.
Those stuff is going to take more than 5 minutes.
although not all night long.
May I ask who made the motion?
I'll also move, and Member Highland, Vice Chair Highland, I think.
Second.
Is there any public comment? Seeing none, without objection.
The motion passes without objection, with Member Copra being absent.
Item number 12. Do I hear a motion to adjourn the meeting?
So moved. Me.
Second?
There being no further business, the meeting is adjourned at 7 p.m.
Thanks, everyone. Thanks, everyone.